Good morning.
Go ahead, go ahead.
Welcome to today's court enforcement hearing. My name is Mirabel Roche. I'm going to be your special magistrate. This is a quasi-judicial hearing, which means it's similar to court, but the rules are less formal. Everybody's going to have an opportunity to be heard regarding their case. I will ask for those who are going to be providing testimony to please stand up for the taking of the oath. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Okay. With that, I will ask the town to please call the first case.
Okay, Your Honor, the first case we have today is Beach Patrol. It's going to be number 1, Brittany Negep. The base officer presenting this case is Harry Lee.
Officer Lee, can you please state your name for the record?
Harry Lee.
And are you employed by the town of Fort Myers Beach?
I am.
In what capacity?
Beach and Street Patrol.
Okay. Are you familiar with case number 1, overtime meter violation, section 28.51, Ms. Negep as the alleged violator?
I am.
Can you please tell the special magistrate how you're familiar with this matter?
While patrolling on my natural patrol on 916, I went into Hercules Drive and access to the beach, checking all the parking spaces for payment of the spaces. And upon looking at space number 38, the space was either ran out or it wasn't paid at all. So at that time, I issued a parking citation to the individual in space 38.
Subsequently find out who the owner of the vehicle was through checking the state database.
I just found out the owner of the vehicle when I got the paperwork today for the court hearing.
I'm sorry, when the notice was, the citation was issued?
Yes.
Okay, all right. And do the photographs that are in the file reflect the alleged violation on the date that you took the photographs?
They do.
You took those photographs?
Yes, I took those photographs.
Okay. And based upon those photographs, how you issued the citation to the car in question and to the owner in question?
Yes, that's correct.
Mr. Magistrate, unless there's any objection, we'd enter into evidence the file that contains the photographs as well as the name of the alleged violator and
Documents in the file are so received as evidence. Have they been provided to the respondent?
no, but certainly can.
And we don't have them on the
Yeah.
TV screens
Oh, I
today.
think that there's, we don't have them, yeah. We're experiencing electrical difficulties.
Oh, okay. Okay, you've seen them? Okay.
Yes, I have. Thank
Please
you.
state your name and relationship to the property, please. I mean, to the case.
My name is Brittany Negep, and I'm the owner of the Jeep Grand Cherokee.
Okay?
So I parked my vehicle, and you don't have the pay thing anymore. You have to do everything through your phone. So I didn't really understand how it worked. So I tried to follow the instructions, and my phone wasn't loading, but I have printed out a screenshot of the code that I got from the website. You know, like I tried to do the thing that I was supposed to do, and then I wasn't getting good reception, so then I walked on the beach that's like 5 feet away because there was buildings around me. Instead of standing there, you know, keep doing the same thing over and over, I walked away a little bit. So when I called on the phone, when I got my parking ticket, because I read the phone number on the parking ticket, he's like, "Ma'am, you walked away." And I'm like, I don't just walk away. I was trying to follow the instructions. And apparently the phone number is on the little board thing too. I did not see that. I was trying to do the URL thing. So, and then on the other screenshot that I have of the phone, it's really big. So that's 11:16. I got my parking ticket at 11:09. My code was sent at 11 o'clock, and I don't think I should get a parking ticket for 9 minutes because I feel like, A, I was being watched, like I walked away from my car and you're trying to give me a ticket. Number two, I'm not an idiot when it comes to using my phone. I'm 33 years old, I'm not 100. And we have a lot of older people that come to our beaches for vacation, a lot of foreigners, and my livelihood depends on Fort Myers Beach. So something needs to be done to make it more accessible. And it's not like a welcoming thing, to give people parking tickets and to make this a hassle.
Has council seen the pictures, the screenshots and the pictures you have? Could you go ahead and please provide them to the attorney, and then that way he can take a look at those, and then I can take a look at those afterwards?
And I'm not trying to split hairs over, $3 of parking or whatever. It's 9 minutes, and it's not as easy as it used to be with the machine where you can pay by cash or coin. Yeah, the screenshot at the top, it says like 7 o'clock, but then when you see the text message sent, it says 11 a.m.
This one is just the code to validate the app. Isn't that just the code to validate the app? Do you have evidence of payment?
No, I couldn't pay because the thing wouldn't load. I did not pay for parking.
But it says that your passport parking mobile pay code is 629.
I tried to use the app. I tried
Okay.
to use the thing, but then it didn't load when I was trying to pay.
And the one regarding the phone number, is that the phone number to the parking app company?
No, these guys.
Oh, local?
Yes.
There's a photograph in the file of the sign with that phone number.
Yeah, and I admit that there is on the sign, but I didn't see it.
We also have, Your Honor, pay stations in Strandview, Connecticut, and Palm, which is close to Hercules, especially Connecticut, that you can pay by phone or
And
credit
actually,
card
The,
or
the,
cash.
the sign actually says it for cash and credit payment, use access, and it lists the access where they are at.
Where is that?
On the same, where you saw the phone, right above it, it says for cash or credit card payments, use access, number 17, number 22, number 30.
I got the phone number from the back of the ticket because I knew to look for the phone number here, but I didn't know to look on the phone number there.
But typically with these things, I mean, I know there's several apps, but normally there's some type of a sign that gives you like the code for the parking lot, or, because I know there's several passports and pay by phone, pay by app. Okay.
Like I said, I'm not an idiot when it comes to the phone. I walked 2 feet away, and I didn't know that there was pay things, but that does make it a lot more convenient.
I would like to respond to her statement that she felt possibly she was watched. I don't sit and watch people to walk away from their vehicle in order to give them a citation. I would never do that, and that's not my goal. So I just want to make that clear.
I'm trying to find what the amount of the ticket, oh, there it is. What is the city requesting, the town requesting?
Yeah, I was going to ask Officer Lee, maybe for some clarification. Officer Lee, during this time frame, did the city receive any complaints from any other users with regard to the app?
Not to my knowledge, not that I know of.
What is
Nothing
it-
further.
What is the town requesting? Unless you wanted to respond to that.
No, but that's a good question.
Okay. What is the town requesting?
The amount of the citation on the face of the citation is $35 plus administrative fee. According to the town code, special magistrate can assess an administrative fee of up to $175.
$35 for the ticket.
Correct, and there's administrative fee up to $175.
Okay.
To be paid within 10 days.
I don't think that was it eventually paid, for parking? Did you eventually pay for parking?
I left after that because
Okay.
I was like, forget it. It's not worth it. The beach smells. It's 9 minutes. This is ridiculous.
So, I'm going to find that the violation as stated in the notice of violation, the ticket itself did exist. And I am going to impose the $35 ticket, but I'm not going to go ahead and do the fees and cost. So
Well,
just
thank
pay the
you.
35 and be done with that. And read the signs. All right.
All right, well, thank you.
To be paid
for-
within 10
To
days.
paid within 10 days.
Well, thank you for hearing me. I appreciate it.
Absolutely.
Have a good day.
Thanks, you too.
Okay, Your Honor, next we have number 2, Carol McCollum. The officer that issued the ticket is Kevin Shashevsky. He is not in town. Officer Todd Sears is handling the case for him.
Mr. Sears, are you employed by the City of Fort Myers Beach? In what capacity?
Beach and street enforcement.
Have you had an opportunity to review the file for this particular code violation, reference number 703-22501?
Yes.
And based upon your review of the file, can you tell Special Magistrate what the nature of the violation is on this particular case?
This is expired meter.
And the citation was, I think the photographs show on 10/29/2019, is that correct?
Yes.
And there's the photograph indicating that payment had been made but had expired at the time that the citation was issued?
No, it appears on this, what happened was she paid the wrong spot. She was in spot number 3. The citation was issued for space 13, or she paid. But on the pay station itself, there's a sign that states, make sure you put in your right spot. As we, if it's a user error, we do not void the ticket.
Result of the incorrect space, a citation was issued?
Yes.
And has did the notice go out to the car owner?
Yes, citation.
And is that in the file as well?
Yes.
And on the face of the notice, does it state the amount of the fine that the town is seeking?
$35 for expired meter.
You have any additional comments that you'd like to state to the special magistrate?
The only thing I would add is that it does state on the pay station that they paid. It gives you 4 instructions. One of them is enter correct space number. Violations will not be voided for failure to follow instructions. So that's it.
I have a copy
Okay, good.
of that.
Good, good.
Has the respondents seen the documents? Okay.
Yes. They've been emailed to the
Including the copy of that one?
yes.
Okay. All right. All right, go ahead, please state your name and relationship to the case, please.
Okay, my name is Carol McCallum, and I'm the owner of the car.
Okay.
Actually, I think It's not actually an expired ticket. The situation is we put in the incorrect number of the space. And my girlfriend and I went down for lunch. She jumped out of the car to go to the pay station, got the ticket. I took the ticket from her, put it in the dashboard. I did not look at the ticket, and I did not realize that she unfortunately thought that we were in space number 13 and we were in space number 3. So when we got back from lunch, we knew we still had time on the ticket. However, we had a parking ticket, and we were a little perplexed, but then when we looked at it and saw the picture, it was indicating that we were in the wrong spot. So we put in 13 and we were in 3. So it was our mistake, however, an honest one at that, and we did pay for the parking. And it wasn't real crowded that day, actually. So I don't think or hope we didn't take a space away from someone.
Did you pay for the full amount of time that you were there?
Yes, we did.
Was there a way for the city to corroborate that there was payment, that it wasn't expired, even if she was in the wrong spot?
Well, the reason it was expired was,
Well, she never had access to
Exactly.
that parking
Exactly.
space.
And that's what the
She
officer
paid for
looks
the wrong
for.
one, I get
yeah,
that.
but yeah, other than that, no, I don't have it with me.
Okay. All right, what is the city requesting, the town requesting?
The imposition of the $35 fine and administrative fee of up to $175.
I hereby find that the violation as stated in the citation did exist. However, I'm reducing the fine to $20 and no fees and cost.
To be
Payable
paid
within
within
10
10
days.
days.
All right, thank you very much. Appreciate it.
Okay, next, Your Honor, number 3, this is for Ryan Close. Officer Kevin Shashevsky issued the citation, however, he is not in town. Officer Todd Sears is presenting the case.
Officer, you've already been sworn in, you've testified that you are employed by the town of Fort Myers Beach, that's
Yes, sir.
correct?
Yes, sir.
Are you familiar with case number 703-22195?
Yes.
Can you please tell the special magistrate how you're familiar with this case?
Okay, on October 7th at about 08:05 hours, Kevin Shashevsky was patrolling the area on Avenue A when he observed a truck parked into a parking spot with the front end in the roadway, obstructing the roadway. So he issued the citation for obstruction of the roadway.
And do the photographs in the file reflect the condition of the vehicle as it relates to the violation of being in the roadway?
Yes, sir.
Was based upon that photograph evidence in your review of the file, are you aware if a citation was issued to the car owner?
Yes, there was, placed on the windshield.
And the subsequent notice was sent out?
Yes.
And on the face of that notice, does it state what the amount of the fine is?
Obstruction of roadway is $50.
Okay. Do you have anything additional that you'd like to advise the special magistrate of? Madam Special Magistrate, at this point in time, we'd like to move into evidence, but the file, not only in this case, but the previous case as well. I apologize.
That's okay. Both documents, both files have been received as evidence.
Were the photographs and the information that are in the file provided to the car owner?
Yes, email.
At this time, Madam Special Magistrate, based upon the evidence testimony presented, we'd ask the Special Magistrate impose the outstanding fine of $50, as well as an administrative fee of up to $175.
Please state your name and relationship to the case, please.
Ryan Close, owner of the vehicle.
Okay. What happened?
I pulled into the parking. I was invited to stay at the guest parking. I'm guessing, I've been told that it's public land, but it's private parking for the residents of the building. the building itself, the parking spaces are little less than 16 feet in length. There's no way a physical F-150 or truck could fit inside the spaces. I was sticking out past the space itself, but when you look at the roadway itself, the sidewalk extends out into the middle of the road where the walking path is, where the ADA little bumper plates are for the blind. That's actually in the middle of the road. So I thought I was okay because it's an old parking lot. It's not properly, I mean, there's lines, but everything's fading. The parking lot paint itself's fading away. I was under the assumption I was good. Found out that I ended up getting a parking ticket, so that's what I'm here for. I do have pictures of the different property markers where the sidewalk is actually in front of the roadway itself and all of that, so.
You were aware that you were past the lines.
Yes, but it doesn't say anywhere compact parking only, no trucks. The length of the space is 16 and a half feet. The average space for most parking is about 18 to 20 feet.
The problem you have here is that there is pictures of it getting into the roadway.
Yes, but I also have pictures as well of the roadway where the sidewalk is, and physically where the sidewalk is. If a blind person wants to walk down this sidewalk and approach the little yellow mats that have the bumpers on it, they would be in the roadway, in the middle of the road. The roadway to enter the road is only a one car, like width of one car. Two cars could not pass to enter this roadway at all.
Mr. Magistrate, and that's why the car hanging over poses and constitutes a violation.
Almost looks like it obstructs the view of that stop sign if you're looking at it from the wrong angle.
Could I show you the pictures that I have of the area? Okay.
He can enter them into evidence. My objection is they have no probative value as to what the violation is.
I haven't-
It's not, we're not alleging that he's obstructing the sidewalk.
The property marker here, that's from the person who painted.
Again, I'm not, it's a,
All right, so let me go ahead and look at that so that I can actually make a ruling regarding relevance.
This here,
Okay?
this is the sidewalk. To approach this, they would, could, blind person wouldn't know they were in the middle of the road. Next photos, this here, this is not actual city marker, marking property lines. That would, on here, this is the length of the road. Vivid, where the numbers are. Feet in front of my vehicle. So the way that the parking lot is actually painted, the person who painted the property, since it wasn't the county and it was private, they could have painted the line 16, 12 feet, 20 feet, almost whatever length they wanted.
What makes you say that that marker has any relevance to the size the parking should be?
This was set by the county. It actually.
Yeah, exactly. There are server markers, but they really don't have much relevance regarding the lines of the parking spots.
The lines of the parking spots were put.
Okay.
So.
All right.
It wasn't done by.
Go ahead and so that they can hear you on the record. Is there anything else you would like to add, sir? Anything
I
further?
have no
from-
idea.
Anything further from the town?
Nothing.
Okay. Based on the evidence presented, I hereby find that the violation as stated in the citation did exist, and the owner did have knowledge that the truck was in the right-of-way. I am imposing the fine pursuant to the citation for $50 and assessing the $175 in fees and cost on this one.
Payable within 10 days, please?
Yeah, but within 10 days.
Thank you. Have a great day.
Thank you.
Your Honor, at this point, we're going to move to the people that are present.
Yes,
So we are
please.
going to move to cases number 31 and 32, which is,
Give me just a second, I lost my agenda.
okay.
Got it.
These are imposition of lien matters.
I'm sorry, we're starting with which one?
31 and 32.
31, 32. Got it. Okay.
This is Abelardo Rodriguez, assessor in interest to the Mark Hewitt Trust for Mark Hewitt. However, that property is sold, and let's see. I don't have anything. Officer Eli Lee is handling the matter. I don't have any.
Special Magistrate, and we, in the file, you will find that the chronology of this particular case, and that an original notice of a hearing was sent on October 14th of 2019 for this particular hearing, but the underlying order was entered back in 2016, and it is, or the notice of violation that was issued was back in 2016, and subsequent, as a result of noncompliance, the case was brought forward before the special magistrate at that point in time, and a hearing took place, and an order of violation was entered. Since that time, the property continued to be in noncompliance. The actual hearing was on give me a moment, August 8th, 2016. The property is currently in compliance, but a fine did accrue as a result of the noncompliance from the date of the hearing. Intervening in the process, the property went into foreclosure. The property was ultimately sold through the course of a foreclosure sale. It is the position of the town that the city's lien was, the amount of the accrued fine was wiped out effective that date, but the day after, pursuant to the provisions, Chapter 162, the property owner, the subsequent property owner took title, subject to the notice of violation and the order violation, and that the fine began to accrue from that date forward. And that we're here now to impose a request imposition of a lien. Again, the property was brought into compliance, but there was a period of non-compliance that resulted in the accrual of a lien in the amount of $44,575, which reflects the 296 days that the property was in non-compliance subsequent to the foreclosure sale.
Oh, thank you.
Sorry.
That's
That,
okay.
unfortunately, is the only one I have. We can make a copy, if you,
I'll give it, I'll do my,
okay. Okay. I have that information, so. With respect to procedurally, it is also the position of town staff, based upon the language in the town code, that the sole issue for this, at this point in time, is determination of how many days the violation existed past the date for compliance.
I might have some more questions before we get there.
Sure.
It looks the order imposing lien on the lien that was recorded, this one was recorded on 8/16/2019. This is not one of those that had the issue regarding proper notice for the
No.
proper notice, and the lien that was recorded on August 16th of 2019 was properly entered.
Correct.
When was when did the property go in foreclosure? Do we have that?
The,
Or this, at least a sale?
the certificate of sale was 11/7/2018. And the date of final demolition, the property was brought into compliance through demolition, was 8/29/2019.
Was recorded after the new owner had taken possession. Is that correct? Because the lien appears to have been recorded on August 16th of 2019.
Right, but the order of violation was recorded on,
So that's when the lien actually took effect.
no, original, I'm sorry.
You want this back?
Yes, no, the original code enforcement order to impose lien was filed on, sorry. No, that's not. I'm looking for the order of violation.
What I have is the notice of violation, which is dated 1/28/2016. According to the lien that was recorded, there was a hearing on June 29th of, I think that's
16.
2016, yeah.
And there was an order,
But it was not recorded, that order was not recorded until 8/16/2019.
no, we're obtaining a copy of the order of enforcement. I apologize.
That's okay.
There is an order of enforcement. It was recorded, and it was recorded contemporaneously with the original hearing date back in 2016.
Okay. So why was there another order recorded on 8/16 of 2019? Oh, awesome, okay. Okay, so yeah, I was handed a lien that was recorded on 10/12/2016.
As a result of various issues raised by the property owner's attorney who is present here this afternoon, we re-recorded the order.
Okay.
I'm sure he can speak to this.
All right, let me go ahead and send it over to, did this, Don want to add anything else?
No.
Okay. Go ahead, please state
Morning,
your name and
Special
relationship to the
Magistrate.
case.
I'm Jeff Wright with Henderson Franklin Law Firm for the
Okay.
property owner, Mr. Hewitt. He's appearing telephonically today. I have him here on my speakerphone. And I do have an 18-page packet I'd like to enter into the record at this point, if you would allow it.
Has counsel seen it? Okay, great. Does your client have a person on his end of the phone to put him under oath?
No.
Okay.
We tried to clear it with staff before that, and we were going to call in, but we're doing it this way.
Unfortunately, if he's not under oath, and I can't take an oath with somebody who's appearing by phone.
I'll keep him on the line then.
You can keep him on the
okay.
line, that's perfectly
But no
fine.
testimony
But he will
from
not
him?
be able to go ahead and provide
Okay.
testimony.
Well, thanks for clarifying that on the front end, and maybe avoid some clunkiness. And
Correct.
I just want to make sure that he can hear us okay, if that's possible.
Yeah, that's fine.
Mr. Hewitt, can you hear us okay?
Yeah, I'm getting, certainly what you're saying, Jeff, and I'm getting part of what the magistrate is saying, so doing my best.
Okay, thank you. Well, first off, I want to say thanks to staff. Daphne and John have been great, and we've been back and forth for a period of many months, going back to April or May. What happened was Mr. Hewitt bought this property in April and became record owner in May of this year. And today's hearing, as I understand it, is, in the words of the town attorney, to impose a replacement lien on the property. Now, I have to point out that I'm not aware, I wasn't aware until just now that they re-recorded an order. I haven't seen that. It's the first I've heard. But that might come up as we go on here. I'm not sure why they would have done that, and if why they wouldn't have given my client notice that they were putting an enforcement order on his property. Nonetheless, John indicated that there's a certain scope to this hearing, determining the number of days is the focus. And I would just point you to the statute, Chapter 162 and the Town Code, which says that an imposition hearing, there's 3 things to consider: the gravity of the violation, actions taken by the violator to fix it, and any previous violations committed by the violator. And under the town's code, you have the authority to reduce or to mitigate the fine. I'm going to try to be quick, and I appreciate your patience. We plan to present this in the following order. I want to sum up some of the facts, the background, and present our legal defenses to the imposition of the lien, and then, if necessary, arguments for mitigation of the lien amount. Okay, about myself, I worked as an assistant Collier County attorney for 8 years, 2006 through 2013, where I was assigned to handle all of the county's liens during the foreclosure crisis. My last 2 years at the county were spent as the code enforcement director. I'm board certified in local government law, and I'm intimately familiar with how these things work, these liens. As I mentioned, Mr. Hewitt became the record owner of the property on May 10th of this year. He has been a visitor to Fort Myers for decades. He loves this town, and he has a residence here in another location for the last 4 or 5 years. He has a solid history of being timely and code compliant. He's going to be using a reputable local builder to build a new home at this property. Now, here's the problem. When he bought the property, there were no outstanding liens or enforcement orders on the property. There was nothing there. You get a title report and it says it's clean. When he contacted the town after he bought the property, staff informed him that he owed them $250,000. So what did he do? He called an attorney, me, and we said, where's this $250,000 coming from? And they said, well, there's 2 liens, both of which are on the agenda today. And they've accrued and accrued and accrued. And here you are. You have to fix the violation. And right now you're at about $250,000. So I got involved, contacted Mr. Herron, and they said, you need to do a lien reduction request. Go to council, get one of those. So they gave me the application. Like I've said, they've been professional and awesome, really, public servants the whole time through. So I get the application, fill it out, narrative, the whole thing, send it in with the fee. There was 2 cases, so we had 2 fees, and sent those both in. And we got a rejection note on May 30th. And mind you, we took title 20 days prior. We got a rejection note on May 30th. So we're hustling, trying to get this problem fixed.
Is that in the package, the rejection notice?
Well, I just wanted to give a little history. I didn't
Okay.
want to bog you down with that. But
That's
no, it's not included
Okay.
in there. But I'll get to some
That's fine.
references there.
Keep going.
So they said, yeah, you need to do a lien reduction. So we file it, submit it, get the money back with a note saying you got to bring it in compliance first. And we said, well, what's it? We don't know what the problem is. And after a lot of back and forth, we decided that, well, he's going to demolish the place anyways. Let's just get the demolition company out there and demolish it. So the demolition was completed on July 5th, 2019, and we have a certificate to that effect. It's in the last page of your packet. Has the date on it, has the building official's signature on it. I don't know why they're shooting for August 29th for today's proceeding, but that's the day that it was formally brought into compliance. That was less than 60 days after he became the record owner on May 10th. So that's hustling. Over the summer, we went back and forth with Mr. Herron on how do we do this? Do we go to council? We're in compliance now. What do we do? And a lot of back and forth. It was summertime, so maybe that played into it. But we started looking at this more closely. And I'm practice local government and land use, and some of this real estate title stuff I want to make sure is right. So I went to a board-certified real estate attorney in our firm, and I said, hey, look at this. Has this been have these liens been foreclosed? They're saying we owe $250,000 and it's growing every day. It looks to me like they might have been foreclosed. So I started doing some research, and we determined, yeah, it was both of these liens were foreclosed. So I contacted John on August 12th, provided it with some case law, and he agreed. The liens were foreclosed. So what are we left with? I said, well, John, if there's no liens on the property, could you do releases just to clean it up and so the next guy doesn't have the same problem? And I asked that they file 2 releases just to avoid ambiguity and correct that erroneous information, which he admitted was not right. There's not $250,000 because the liens were foreclosed several months before. The town's response was, you heard it today, the fines are going to be adjusted to reflect the foreclosure of the lien. We acknowledge that. Liens are foreclosed. But the fines would somehow start right back up. You heard him. Start right back up the day after the foreclosure sale. I'm not sure where that's written, but that's the town's position. Because, and here's what their logic was at the time in August, because my client took the property subject to a recorded order of enforcement. Not the lien orders, but the recorded orders of enforcement. So on the 14th of August, the town attorney wrote me, pointed out the statutory language in 162.07, subsection 4, and I have highlighted that in your backup. I've numbered the pages. It would be on numbered page 11. And he quoted that statute, and he said, Jeff, you know, a certified copy of that order may be recorded in the public records, and that constitutes notice to subsequent purchasers like your guy. Your client, this is a quote, your client knew or should have known of the code violation because the order of enforcement is a matter of record. So I said, wow, I've looked through the record. I didn't know that there was an order of enforcement in the record. So I looked, and I couldn't find one. So I said, John, could you give me a copy of that order of enforcement that you are relying on to punish my client? He responded, quote, "We will provide you with a copy of the recording information for the enforcement order via separate email." And that correspondence is in your backup as well. We never got it. And that was in August, despite my repeated subsequent requests in weeks that followed. I said, "John, do you have the recorded order of enforcement? Do you have it? Because you're saying that we should have known because it was a matter of record," but it wasn't. In summary, on the history, there's a lot of history, but the most important fact is that Mr. Hewitt, the new owner, did not have any notice that there was a violation on the property when he bought it. The liens had been foreclosed, and there was no recorded order of enforcement. How do you know? So you buy it free and clear after a foreclosure. They admit that the lien's wiped out, but for some reason they're given this order of enforcement, which was not recorded, some sort of super priority status where it jumps back into action, giving it higher priority than code liens, higher priority than federal tax liens, and higher priority than everybody else. It jumps back to life. That's their position. But he didn't have notice. That's the problem. So, now to my request. We don't think it's appropriate to impose a lien at all. And the town, as I've said, and as Mr. Heron said, they're relying on its order of enforcement as the basis for the lien that they're requesting today. I don't know which order of enforcement they're talking about. Is it the one that wasn't recorded, or is it the one that he just told us about that he did record? He never told me that they recorded one. Apparently they did one this year. I don't have the date of that. Anyways, I did ask him for it. He never gave it to me. And to hear that they've recorded one since we've been in all this discussion is really a big surprise for me. It seems like at least the courtesy of, hey, we're putting an order on your property, not to mention notify the client and give them a chance to correct the violation before going straight to a lien. No hearings, no notice, no nothing. Now, they're relying on that order of enforcement. It was not recorded when my client took title. The town attorney assured me that they were, but they weren't. The statute says, in order to provide notice to subsequent purchasers, the order needs to be recorded. In addition, even if the order of enforcement had been recorded, it was foreclosed. These don't have some super priority status. The order was entered between the filing of the foreclosure list pendants and the certificate of sale. This one that he told me about in 2019, I haven't seen it. I don't even know the date on it. I tried to jot it down, but it's the first I've heard of it, and I don't think it's fair to tell us, oh, by the way, we slapped an order on your property without any hearing, but that's apparently what they did. So I'm focusing on this effort to impose a lien, and even if it had been recorded, it was a foreclosed order. They admitted the lien was foreclosed. Our position's order was foreclosed as well. The order was entered between filing of foreclosure list pendants and the certificate of sale. It's an unrecorded town interest. Under Florida statutes and case law, an unrecorded interest can't continue to encumber a property after a foreclosure. After the foreclosure, the property was free and clear of any unrecorded interest to the town. The statute is the list pendants statute, 48.23, that says exactly that. The case law, and we shared this with Mr. Heron, is Ober versus the town of Lauderhill, excuse me. And that is page 1 of your backup materials. And if I may direct you to that case at this point, if you look at page 3, I've highlighted certain portions of that case where they're quoting the statute. And it says, the recording of the list pendants for the foreclosure constitutes a bar to the enforcement against the property described in the notice of all interests and liens. Well, we're not dealing with a lien, we're dealing with an interest, an unrecorded interest. So it gets rid of all interests that were unrecorded at the time of recording the notice. That's what we have here. The town's enforcement order was unrecorded at the time of the list pendants notice filing. If such proceedings are prosecuted to a judicial sale, which they were, The property shall be forever discharged from all such unrecorded interests and liens. And the court goes on to say, the language of the statute is broad. It applies to all interests and liens. This is consistent with how foreclosure suits operate in the real world. You get it free and clear. And the court went on to say in the last sentence of their opinion that if you have a problem with this structure, this regulatory structure, it's in the legislature's hands. Change the law.
When was the foreclosure started?
Timeline here.
And when the lease pendants was recorded?
The foreclosure list pendants was recorded in 2012. The code enforcement liens, which are now gone, they were recorded in 2016. The enforcement order was entered in 2016, never recorded. And in 2018, the final judgment was entered in the foreclosure.
That the lease pendants was filed in 2018 and the final judgment in 2018. Are we still talking about exactly the same case?
Yes, and just to clarify, the list pendants was 2012.
I understand that.
Okay.
I just want to make sure because there's a big gap that it was exactly the same case.
Yes, yes. And in fact, the Ober case, right at the end, it does say, this kind of goes to your question, the practical problem in that case is there was a huge lag in the foreclosure. It took forever. And he said, the practical problem in this case is a long lag time between the foreclosure judgment and the sale. Well, and it really meant the length of the foreclosure. The facts there were different than here slightly, but they're saying that if you have a problem with the arrangement, it's in the province of the legislature. So there was a big gap in this foreclosure. It took 6 years. And yes, it was all the same case. Also, the second DCA in Florida has held that a property owner like Mr. Hewitt has a compelling interest in retaining their real property free from undue interference or improper clouds of title, and that residential property rights are among the basic substantive rights protected by the Florida Constitution. You have to provide proper notice before clouding title to residential property. We think it would be an inappropriate and improper clouding of Mr. Hewitt's title. It was free and clear following the foreclosure, and this is to our argument that there shouldn't be a lien at all. We respectfully request that you find that, number one, the underlying enforcement order was never recorded, and this effort to scramble at the last minute and shove one in the public record is the first I've heard of, and it's really preposterous, frankly. Number two, the property owner, as a subsequent purchaser, did not have proper notice of the violation or the enforcement order. He never, to this day, has gotten notice. The town's order of enforcement has been foreclosed. The original one, it was never recorded, ever. The one that was in effect when he took title was not recorded. And we ask that you order that no lien will be imposed under these circumstances. I want to make a final note on the super priority. I just want to reiterate that there was the city of Palm Bay versus Wells Fargo was a big case. A lot of local governments thought code enforcement liens are special. They're super priority. They go above everybody else. And the local governments got reprimanded by the court and told, code liens get in line like everybody else. The book and page number controls your priority. Well, what they're suggesting is that, yeah, code liens may not be super priority, federal tax liens might, but our order of enforcement that wasn't recorded, it's a super priority order, and we'd like to get you for $75,000. And that's the combined value of the two cases here. Now, if you are inclined, I am prepared to present our arguments in favor of mitigation of the amount. but I thought I'd ask
Let's
that.
go ahead and do one step at a time, if
Sure.
you don't mind. Does the sit-down have a response to that?
Oh, yeah. And you know, Mr. Wright and I have worked on this matter for some time, but I would take issue with how he's characterized some of the conversations. The city has never taken the position, and I've never stated to Mr. Wright that there's any super priority. I'm well aware of the Palm Bay case. It is binding law. You know, we do not have a provision in our code that says that our code enforcement liens have super priority. What we are simply saying, and what we've advised Mr. Wright, and we're arguing here before you today, is that state statute that Mr. Wright has provided to you clearly states that if there is a copy of an order in the public records putting a property on notice, irrespective of the foreclosure, they take notice of that, and they are, as the statute says, shall constitute notice to any subsequent purchasers, successors in interest, or assigns if the violation concerns real property, and the findings therein shall be binding upon the violator. When Mr. Wright asserts that the city agrees with him that the lien has been wiped out, it's the lien amount, but the order that's been recorded is still valid, and his client did take title to the property subject to that notice. To the extent that there may have been a title issue, we're unaware of that, and I would respectfully suggest that that's between Mr. Wright's client and the title company for not picking up a clearly recorded code enforcement lien from 2016, which we've provided to you. Furthermore, we have a city witness that can testify that prior to taking title to this property, Mr. Wright's client did contact the town and was advised that there was a code enforcement violation on the property that was still outstanding. So to ask that the city witness come forward, I'll have her sworn in, and she can testify that she was contacted. I don't believe she's been sworn in.
I stood back.
Oh, you did?
Yeah.
Okay.
Go ahead.
Could you please state your name for the record?
Kristen Schumacher?
And are you employed by the town of Fort Myers Beach?
Yes.
In what capacity?
Code enforcement admin, short-term rental?
Okay. Are you familiar with this case?
Yes.
Were you contacted by the current owner, Mr. Wright's client, who I believe is on the phone, regarding this property and any code issues?
I can't specifically say him, but once it was in foreclosure, I received hundreds of phone calls regarding it, and I believe I did a lien search on it as well.
Okay. And what did you advise anyone who inquired about the property as to the status of the code enforcement case?
There were 2 liens filed. One was CE 160025 and one was CE 160026, and I suggested everyone call a real estate attorney regarding these cases because there's a lien filed.
To the best of your knowledge, prior to Mr. Wright's client taking title to the property, were the violations brought into compliance?
No.
Okay. Nothing further.
I have a quick
Dr.
question,
Crosser?
if I
Yes.
may. If you ran a lien search today on this property, what would you find?
I'd have to look at it right now just to be specific.
Would there be fines owing today?
You mean fines accruing or fines owing? I'd have to look in the computer and just make sure.
The city will stipulate that the property is currently in compliance, and it's so stated already. But there was a time after Mr. Wright's client took title to the property with a duly recorded lien instrument that his client was on notice of the code violation, or should have been on notice, as we stated in our email communications. And in fact, after his client did take title to the property, they did come into compliance. But there still was a period of time in which the property was in non-compliance after the property was sold at the foreclosure sale. And according to state statute and the town code, whoever acquired title of the property, including the initial mortgage holder who foreclosed on the, took title to the outstanding violation. And, you know, it's my general experience, having, as Mr. Wright has also done this, that's how it is. And the Ober case doesn't necessarily dispute that. The factual scenario in the Ober case is very different from here. And the reality is that the code violation, that's where the code violation started, and liens were entered. Here, goes back to 2016, that this has been ongoing, open, notorious, to use some of the case law language that's out there. And I would suggest respectfully that the Ober case does not mean that the orders that are of record that say the property's in violation are somehow eliminated through the foreclosure process. What may have accrued to that date may get wiped out, and we have no issue with that. But day after, whoever has title of that property takes title subject to the code violation and the order that's out there.
I just have to,
response?
yeah, if I could, I just, I'm hung up on this. It was already in the public record. It seems to me that they're making reference to both the lien was in the public record when he bought it, and the order of enforcement was in the public record.
The code enforcement order to impose lien. That's
Okay.
what we're relying upon.
Okay, so here we are using a lien to impose a lien. That lien has been foreclosed. It's a town interest that pre-existed the foreclosure, and it was wiped out. I mean, they might like to ride that horse still, but that horse is dead. It's a dead lien. It's been foreclosed. It's a town interest that they no longer have. So I think, humbly, I think that the right thing to do when you have a foreclosed code enforcement lien is to start over. You have to reserve the person. That way you're covering the notice. It's residential property. You don't want to run into situations like this where you're alleging $75,000 or $250,000, but the basis for that amount is shady. He just said it's the lien. Well, the lien's been foreclosed. No, it's the enforcement order. Well, the enforcement order was never recorded. So he said when he just spoke that there's a state statute that says if there's a copy of the order in the public record, I think he's referring to the lien. But that lien's been foreclosed, so they can't use that as a basis to impose a lien. Apparently they're relying on the enforcement order, the underlying enforcement order, and somehow, I never said that their code says super priority, but when you look at this, they're basically saying that that order of enforcement survived the foreclosure. It was never recorded, which is a defect. But even if it were, it doesn't have a super priority status. It gets foreclosed too. So we do have another argument that we'd like to make. I want to reiterate my request to not impose a lien today, but to the extent you would welcome mitigation argument, I'm happy to provide that.
Madam Special Magistrate, one last thing. And I'm reading directly from the order to impose lien recorded in the public records on 10/12/2016. This case was first heard by the undersigned Lee County hearing examiner at a public hearing on June 29th, 2016. It then goes on to state, on September 20th, 2016, written, competent, convincing evidence was provided that the violation had not been abated in accord with the above order, and the special magistrate therefore finds and decides, and then makes a specific determination that there's a violation of the code and authorizing the imposition of a lien. Anyone who reads this, any reasonable person, would be on notice that there's a determination of violation, and under the statute, certified copy of such order may be recorded in the public records of the county and shall constitute notice to any subsequent purchasers and successors' interests or assigns if the violation concerns real property, and the findings therein shall be binding upon the violator. We're not making up an argument here, nor I'm suggesting, by the way, that Mr. Wright is. We're just simply relying upon state statute that is, in our opinion, self-executing. Again, we're not here asserting that we have the right to impose a lien for the full amount that may have accrued from October 12th, 2016, when the order was recorded. Rather, we're asserting and arguing that based upon this plain language of the statute, that the date after the foreclosure sale, the new owner took subject to these orders, or to this order, that clearly states the property is in violation, and that there's, and that it needs to be brought into compliance. It was not, and as a result, back to the original order, there's an accrual of a fine.
Provide him one opportunity to go ahead and respond to that, and then I'm ready to go ahead and issue a ruling once he goes ahead and.
He said, obviously, he took the property subject to this order. I'm not sure what order he's talking about. I think he's referring to the lien order. What's confusing to me is I have an email from Mr. Herron that says the town's position, which has not changed from the first time we discussed this, is the foreclosure erased the lien and the accrued fine that had accumulated. It did not wipe out the order of enforcement. So they're conceding that the lien was foreclosed, yet they're plucking language out of that lien order to basically say he was on notice of that. But when you review title and you see that a lien's been foreclosed, that lien is no longer a town interest that can be enforced. Now, as to the, if you'd like, I can move on to the mitigation.
Let me go ahead and address the issue of the lien, and then we can do mitigation. I'm going to find that I agree with the fact that the lien itself as a security interest against the property was foreclosed by virtue of the mortgage foreclosure action. However, though all the future purchasers were on notice that there were violations at this property, and as such, when they purchased the property, they were taking it subject to and responsible for those violations. There is sometimes a confusion among real estate attorneys. The fact that mortgage foreclosure will go ahead and wipe out the interest that is the lien, that it somehow wipes out the violations. That is not correct. The violations continue to exist and need to be addressed, which I commend your client for taking action right away and correcting that. So to that extent, I agree that the preferred method would have been to do a new notice of violation on the name of the new owner and proceed, but I do understand that he was well aware that the violations did exist, that there was plenty of notice on records, that the city provided notice verbally also that the violations did exist and would need to be addressed by whoever purchased the property thereafter. Okay, with that, I'll let you go ahead and proceed with the mitigation portion.
Just want to reiterate that we disagree with the town's position on that, but we do appreciate your analysis. Next up, the mitigation request. Now, as I mentioned at the beginning, there's three things to consider: the gravity of the violation, the actions taken by the violator, and whether they have a history. And just when you consider the circumstances here, very light gravity. We were talking peeling paint and an unpermitted deck. I'm not sure that there was any public danger or health concerns, but relative to other types of violations, this is, I'd say, light in gravity. The prompt actions that the property owner took to bring the property into compliance upon taking title, he knocked it out really quick, and his clean record, he's got no previous violations. Those are the three things to consider. Just to go into a little bit more detail, the fines, and these comments that I'm making apply to the next case as well, and hopefully we can maybe be efficient and use some of the benefit from the economy of scale there. But we think that $75,000, or in this particular case, $40-some thousand in light of the violation is harsh. And as far as the actions, like I said, he fixed the problem within 60 days of becoming the record owner, which is pretty quick to find a contractor and get it done and get the building official out there to say he's done all in 60 days, less than 60 days. He has a perfect record. And I also wanted to point out that staff, I mentioned this earlier, staff says that compliance was confirmed on August 29th. Our certificate of compliance, page 18 there, says the compliance date was July 5th. That was 55 days prior to the compliance date that the town is stating. That's a $13,750 difference for the two cases, $250 a day in the combined cases. Again, that's in the record. And if you are inclined to impose a lien, obviously we want you, if you're basing it on the number of days passed, we ask that you remove those 55 days. from your calculation. And finally, we'll wrap it up here. A couple of comments, maybe policy arguments, if you will. Mr. Hewitt, the new owner, came in and he fixed a problem, and there wouldn't be a code violation if these violations didn't affect the public. So he fixed a problem that affects the public, the aesthetic condition of the property. The town's significant efforts to punish him are really hard to understand. We would not be here if the town's information that we requested was accurate. They said that there's a lien for $250,000. If that had been accurate, maybe we wouldn't have gotten into all this. But that raised our flag, and but we wouldn't be here if we didn't bring it to their attention. There's an excessive amount of fines. What is the problem here? And we requested that they correct that inaccurate information. We don't think Mr. Hewitt should be punished under these circumstances. We also think it's a good policy for local governments to encourage private efforts to improve properties, bring them into compliance with town codes. Punitive fines against the subsequent owner who is committed to fixing the problem should be considered for significant reduction, and we request that you reduce the fine to 0 or as close of a number to 0 as you can provide. And that's all I have, unless there's questions.
Thank you, Special Magistrate. Again, I take issue with the characterization that Mr. Wright has alleged or argued here this morning. That the town is somehow trying to be punitive to his client. We've done nothing but follow the procedures in our code and in state law. If Mr. Wright and his client believe that the fines that are allowed to be imposed under the state statute and our code are punitive, then his recourse is the legislature. So we've done nothing improper nor punitive with respect to his client. We've done nothing but follow the law. With respect to the days of violation, again, there is a unfortunate misunderstanding, in my opinion, that occurs fairly frequently, which is property owners who have code issues and code violations may go to the building department, to whatever it is, the particular department that they have to obtain a permit from to potentially comply with the violation, but never follow up with code enforcement. So when the materials that have been provided says, well, there was a CO issued on X date, which is 55 days short of when the staff filed their affidavit of compliance, because for 55 days, the property owner never notified code enforcement that there potentially was compliance. Had they done so, an earlier inspection could have been performed, and an earlier affidavit of compliance could have been entered into the record. So it's, again, nothing that town staff has done, because all the orders and everything that the town has in the code says it is the responsibility of the property owner to secure inspection and determination of compliance. Why he did or didn't do that, I don't know. But that is the information that code enforcement staff has, is that the property was brought into compliance on the date set forth. As a result, there were 296 days of non-compliance.
Have the date when the demo permit was pulled?
I might have that date. Complete demolition of main house. It would have been between May 10th and July 5th, that's for sure. Let's see, I'm not sure if my client has that handy. What I would point out, I'm not sure, you may be trying to help us, and I certainly don't want to interfere with that, but there is a certificate, code enforcement is within community development, I believe. I have in my hands a document that's titled Certificate of Compliance, issued by the Town of Fort Myers Beach Community Development, dated July 5th, 2019. So to the extent we should have informed the town, I'm not really sure what else we could do.
I'll make it very easy. Even though typically we rely on the testimony from the code enforcement officer, it is typically because we don't have any alternate way of proving compliance. You have provided compliance. So right now, even though I'm not entering my order right now, I am inclined to go as of the date of the certificate of compliance that you did provide. So my next question is regarding when was the permit application date, or when was the permit issued for the demolition?
According to our information,
Issuance date.
the demo date was 8/29/2019.
I know that's I want the permit
Yeah,
date.
we're trying to get that information. Give us a moment.
Gentleman in the front row has informed me that it's July 5th, 2019, which happens to match the certificate of compliance date. Kind of puzzling that you could apply and comply on the same day, but
Yeah,
I'm
that's why
thinking it predated that.
I think the city's also looking to verify what the issuance date of that permit was.
Okay, well, tell me.
Your Honor,
Yes.
I work here. The date that Mr. Wright is suggesting was the date it was finalized. It was actually the date it was applied for. It was finalized again, and I have emails from Mr. Wright that say that he's requesting an inspection, and the inspection, which was in August, and I told him that the inspection was scheduled for the next day. If you go and look at our system, and I have a copy of this, you'll see that the date, 6/17/19, is the date the permit was issued, not the date that it was final.
What was that date? Give me that date again?
6/17/19, is that correct, John?
That's the date the permit was issued?
Yes.
Oh, great, thank you.
And I would agree with,
And it sounds like the demolition was actually completed on 8/17/2019, according to the town's records. Would you like-
I'm not sure what the town's records, that might reflect when they confirmed the compliance, but my understanding, and I remember because I emailed the town manager and the town attorney in July and several times and said, we're in compliance, And then I asked them again, could we get some confirmation that we're in compliance? And that was in July and August. And eventually they went out there and confirmed compliance. So I'm just going by the certificate, which is the most official looking acknowledgement of compliance, and that's dated July 5th.
Well, according to the town's records, the permit was issued on 6/17/2019. And that's the date I was actually more interested in. Do you know what was the delay between that 6/17/2019 and the demo actually taking place?
My recollection is just going back and forth with my client who was out of state trying to get the contractor on site, and it might have taken a couple weeks to make that happen.
This one, I believe the daily was 150 a day?
No, I take that back. In case CE 160025, it was 150 a day, and on
The other one was 100.
100, and then
So I'm doing right now the one that was 31 on the agenda. The one that was resolved by, well, actually, they would have been both resolved by virtue of the demo. 510?
Yes, ma'am. And I should probably, not to mess it up, but he took, the deed's dated April and it took title in May.
What do you mean took title, just because it was
Became-
recorded?
Became record owner, yes, yes, yes.
Okay, so he actually did have it since 429.
Y-
What was the
yes.
date of the deed for
Deed itself 4/19,
49?
2019, and then it was recorded on 5/10.
About to issue my ruling, is there anything else either party would like to add? Yes.
Staff would, at this point in time, request to enter into the record the file. With regard to CE 160026, our file that we're providing to you, and Mr. Wright can take a look at a copy of it. We're also putting in there the code enforcement order to impose lien dated, same date as the previous one, but for this particular case, it's not in the materials that have been provided to you, so we'd like to enter that into evidence, into the record. So, and then
Always
nothing further.
council's documents. Anything further from you? Okay. All right, I hereby find in regards to case number, hold on. 16-0025, that the new owner was on notice that the property had code violations and was on notice that those were pending by virtue of the documents that had been recording in public records. However, the property was not subject to any liens at this time. Based on the evidence presented, the property owner became the owner of the property upon the issuance of the warranty deed on April 14th of 2019. And that the permit was issued on June 17th of 2019, that the demo was completed on July 5th of 2019. For purposes of this order, I am imposing, I run it at 60 days, basically from the date of warranty deed to the date of the application of the permit, which is about 60 days. That comes out to a total of $9,000. I'm reducing that even further to $4,500. That's as to the one case. Right. Do you want to present?
In that regard, you are authorizing us to record a lien to that effect?
Yeah, let me go ahead and do the certification order. Yeah, by virtue of the property owner being on notice, I am of the violations. I'm going to certify the prior order only effective as of the dates I just mentioned, and a reduction to the $4,500.
Authorize us to record, staff to record liens?
Yeah, by certifying, it becomes a lien.
Okay. Based upon Mr. Wright's statements and staff, you know, in the next case, the facts and the arguments are the same. So it's in your.
Wait, to the same argument, same thing?
Yes, I do, thank you.
Okay. Running on the same numbers of the warranty deed having been issued on April 14th of 2019, and the permit application having been, the permit having been issued on June 17th of 2019. That puts us about 60 days. I also find that the actual compliance date by virtue of the demo is going to be July 5th of 2019, but for purposes of this order, I'm running it at the issuance of the permit, which tells to me that the property owner is taking action and doing what he needs to do. That amount comes to $6,000 because that order was, instead of $150 a day, was $100 a day. I am reducing that $6,000 down to $3,000.
The admin fees in both cases?
Yeah, I'm going to go ahead and not authorize the admin fees for
Okay.
either of these cases. I'm just going to allow for the new property owner for the payment of just fines, that's it. And that's in reference to that 16-0026, which is the one that I just ordered, the $3,000 fine, by virtue of my certification of the prior order, that the property owner was on notice. However, he did take quick action into remedying the violations, and as such, I'm reducing that to the $3,000, which shall become a lien against the property. Hopefully, you'll pay it before that, and done.
Thank you.
Thank you.
Thank you.
Next case, please.
Your Honor, at this time, we'd like to call case, it's number 34 on the agenda. This is Beachfront Escapes. This is also an imposition of lien.
Special Magistrate, this case originally started in 2017. A order of enforcement was entered on May 31st, 2018, that found the property owner to be in violation of the code, gave the property owner hold on. Compliance date of July 18th, 2018. And to obtain the permit and implement the permit by July 26th, 2018. If not, a fine would accrue or begin to accrue from that date forward. The property is in compliance, but past the date specified in the order. A notice of hearing for the imposition of lien was sent out to the property owner, and we're here this afternoon. We'd ask that Special Magistrate enter an order that the previous order of enforcement has not been was not brought into compliance within the time specified, and that as a result, a lien in the amount of give me a moment.
I don't believe I have on this one the original notice of violation.
There were 387 days of noncompliance from the date of July 18th. Property was, sorry. On 8/19/19, sorry. Was the date the the town issued a certificate of compliance. I'm sorry, the Special Magistrate asked, made a comment?
I asked for the original notice of violation, and the reason I asked for that is I see that the order from the previous magistrate required the completion of inspections in addition to the issuance of a permit, and that is going to be depending on the type of violation that was noticed on the notice of violation.
Putting out a copy. So it can be-
Typically, if it's a violation of 105,
Yeah,
work
so-
without permit by issuance of the permit. That's it.
It was without, work done without a permit. This particular one was, notes indicate here.
Happen to have a notice of the violation, the original one?
I can't hear you.
Do you remember if you have, do you have the notice of violation, the original one by any chance?
No, not the notice of violation.
Okay.
Yeah, the underlying violation was work without a permit remodel, that there was interior remodeling to the restaurant. That's what this particular case of the notice of violation was issued for.
Right, and that was the single line item violation?
Yes.
Okay. So what was the date that when they obtained the permit? That the permit was issued? That's okay.
8/28/2018.
All right, is there anything further from the city?
Subject to.
Of course.
Yeah.
Of course.
No.
Let's go ahead and hear from the respondent. Please state your name and relationship to the case.
Right. For the record, my name is Beverly Grady. I'm with the firm of Rutzo and Andrus. I'm representing Beachfront Escapes, LLC. And first, I'd just like to hand out some exhibits.
Present them to the council first, and then you can give them over to me. Just council first. Oh, you have a copies for him? Oh, perfect. Awesome. Thank you.
Good morning. I am representing, as I said, Beachfront Escapes LLC, which is solely owned by Lau Klein. Lau is over 80 years old, and he is the owner of the property. And through contract, he has a contract with Mr. Joseph Orlandini, who's here. And Mr. Orlandini is here because he's under that contract responsible for the property and its operation and its upkeep. So to review, I've handed out a letter. It was dated, you'll see, June 20th, 2019, because this case was actually on the agenda, at the end of the agenda on that date. And when we got to the end of the agenda, we were advised that this case is withdrawn by the town. So we got new notice, and it was placed on this schedule. So I'd like to just review some of the history and review the exhibits that I've attached to this correspondence. On May 31st, 2018, a special magistrate hearing was held on CE 17-0870, Work Without a Permit, Restaurant Remodel, 1740 Estero Boulevard. I've attached the minutes of that special magistrate hearing regarding that case as Exhibit 1. Also attached as Exhibit 2 is a copy of the Code Enforcement Order dated May 31st, 2018, where a compliance date was set for July 18th, 2018. The applicant applied for a building permit on October 10th, 2017, predating any violation. The permit was approved by the town on July 31st, 2018, only 11 days after the date to abate, and actually picked up on August 28th, 2018. So today, we are requesting that the lien imposition would be the time period between the date of required compliance until the permit was actually issued on August 28th, 2018. And we ask this pursuant to the Florida statutes, as well as the Town of Fort Myers Beach Land Development Code 2-427B2, where the special magistrate is authorized when considering the imposition of a lien to take into account the gravity of the violation, and we also want to discuss the actions taken by the violator to correct that violation. Once the building permit was issued on August 28, 2018, all work thereafter was legal. The actual violation was work without a permit, and one will recall that the permit was requested October 17th, 2017, and that was just a month after Hurricane Irma and the damage that was caused there. The permit went back and forth between Lee County and the town, but was issued on August 28th, 2018. As Exhibit 3, we have a permit history for that permit, COM 17-0338, that was approved by the town on July 31st and issued on August 28th, 2018. All the fees were paid for the building permit, which included plan review, site review, floodplain fees, as well as for other alterations. And if I could just turn your attention to Exhibit 1. Page 2 of Exhibit 1 is where the case begins. It's a violation that's new, work without permit, restaurant remodel. You'll note that that is not cited as a repeat violation. And if you read the minutes, you will hear there's no clear testimony as to the extent of the work being done. There is statement by Ms. Jacobs, the former code enforcement officer, that the application showed where the equipment was moved to before the permit was issued. She testified that the permit was still under review. We would respectfully submit that in looking that the special magistrate did find a violation and that Mr. Orlandini agreed to obtain the permit, and there was no finding of a repeat violation. And considering that this was immediately after Hurricane Irma, we do find that the fine of $250 a day was one of the highest imposed in the town and was excessive. We would also like to review Exhibit 2, which is the, let me get to that page. Exhibit 2 is the code enforcement order that was implemented by the special magistrate, and the action was for failure to obtain a permit for remodeling. And I do understand it's the permit and inspections, but I would respectfully submit that since the permit had not been issued at that time on May 31st, only granting 45 days to obtain the permit plus all the inspections and do the work is an unrealistic time period. And therefore, the permit was ready for issuance on July 31st and picked up on August 28th. And thereafter, all work was legal and in conformance with the Land Development Code and the Building Code. I've also attached Exhibit 3, which is the final page, which shows the permit. In looking at E-Track, which used to be available online, it wouldn't let me actually print out, but it does show the list of inspections. And as of this time, yes, in June 26, 2019, the permit was approved and finalized. All the work had been completed and it was inspected. We would respectfully submit that when you look at the gravity of the violation, and that we would request you take into account that some of the damage being repaired was from Hurricane Irma, that the applicant had filed for a permit prior to any violation or citation. And I think in many of these cases, the person is cited first, then they come in for the permit. In this instance, in order to mitigate their damages, they applied for the permit, but it was issued in August of 2018. Based upon all the work being legal after the permit was issued, and based upon obtaining all the inspections and the permit being finalized, we would request that there be a reduction in the imposition of the lien so that the period of the fine would run from July 18th, 2018 until July 31st, 2018, when the permit was approved, or at least not past August 28, 2018, when it was issued. And we would request that reduction in the amount to $50 a day. And if you have any questions, Mr. Orlandini is here, as he is the one who procured the contractor and the subcontractors and requested the inspections to be completed. And we think that that amount would be more than sufficient as a lien imposition, and would request you take into account those factors that allow you to permit a reduction from what the town has requested.
I have a quick question for the town. Was the permit that was issued on August 28th of 2018, the scope of work included therein encompass all of the violations, the correction for all the violations in that notice of violation?
No, that's part of the issue, is that the permit that was applied for, and there's certainly a disagreement that it did not include the scope for which the citation, the notice of violation was issued. As to your first question, if I can go back a little bit, the notice that it is in the file, you have a notice of code enforcement hearing. It is, and the reason why it's that way is because it was cited as a repeat violation, and under the state statute and the town code, you don't have to issue a notice of violation for a repeat violation. You can go straight to the hearing, and that's set forth in the notice of code enforcement hearing that's in the file. And then when you.
If I could just respond, because it's right on target. If you look at the agenda for the meeting of May 31st, 2018, where this case was heard, and if you review the code enforcement order that was adopted May 31st, 2018, and if you review the minutes of the hearing, there is no mention of repeat violation.
If I may, Special Magistrate, I believe that argument is improper. It's a collateral attack on the original hearing, and that's.
I'm going to
that's
make it very simple. I mean, I'm here to go ahead and impose a lien on an order that was entered on May 31st of 2018, which has a fine of $250 per day, and that is at the top end of the non-repeat violator rate, so it's perfectly legal.
I'm
Even
not saying,
without-
I'm not saying it's illegal. I'm just
And
asking.
it's not even the amount that would be imposed
Right.
anyways for a repeat violator.
I was just submitting under your factors that you could look at, that the applicant had actually asked for a permit predating any notice of violation or any violation by the town. So there was an honest effort to come in here and get the permit, repair the hurricane damage, but it did take quite an extensive time to actually obtain the permit.
What was the reason behind the delay in the permit?
Joe, can you respond to that?
What was the delay? Oh, sorry, I thought you were asking me to repeat it.
The delay from the time of the
You
application?
got to do the name and relationship.
Joe Orlandini.
Okay?
You're asking the question of what was the delay from the time of the application to the time of issuance of the
Both
permit?
between the time of of actually putting in the application and then the delay between the application and getting
Issued it? It was a constant critique and back and forth with reviewers and what requirements were requested by them for the permit that was applied for.
Okay, and
No.
did it take as long as it did? Thank you. Oh, awesome.
We'll testify to that.
I could. The minutes do respond. First, there was no delay in requesting it. The hurricane hit on September 10th, 2018, and the application was filed. 2017, and the application was filed October 17th, 2017. So we just.
2018,
Irma was 17.
17.
17 for Irma.
Yeah,
Yeah.
2017 for Irma.
Right, so the
We're talking
permit.
2018 here.
The permit application was filed in October 2017, just a few weeks after the hurricane. And there was no violation of an issue, so the permit was requested. The violation was found in end of November by the staff. And in the minutes of the May 31st meeting, there is testimony of the numerous requests for additional information so there was response. There were letters coming on behalf of the town requesting additional information and revisions and responses being provided by Mr. Orlandini. And some of those dates are actually listed in the minutes of that meeting. So finally then the permit was actually issued within 11 days after the time frame set by the special magistrate for full abatement.
But you're telling me that the application was done shortly after Irma, but the violations that are the subject of the notice of violation did not come into play until November. So that would.
Of 2017.
2017, which would tells me that the permit that was applied for shortly after Irma is not encompassing of the violations that were found.
Oh, well, Irma was September 2017, applied for the permit October 2017, and the violation was the end of November 2017.
That is the
That's
issue.
exactly where
That
I'm
is-
going.
that
That's
is-
exactly
That-
where
that
I'm
is the-
going. It's like you have a permit application that was done before the case for the court enforcement case was even brought up. The court enforcement, the violations
Not
were.
brought up, even cited.
Exactly.
Okay.
Exactly, which leads me to believe that that permit that was applied for is not the full scope of the violations that were found thereafter.
And to add,
you need to
and the
answer
work is taking place.
Actually, if I could.
That's the problem as well,
uh,
without the benefit of a permit.
Bear with me, if I could
Go
explain.
ahead.
The property after Hurricane Irma was damaged on the interior due to not necessarily flooding from rising water, but it was from rain coming in from open holes in windows and openings that were just never covered at the time when the current tenant was using it. I went into the building roughly 2 weeks after the storm, and that was a property I was late getting into. I had a tenant that was actually out of town at the time. I checked on the unit, and it was trashed. It was unusable. It needed to be repaired to reopen. So I contacted the code enforcement officer at the town and made her aware, which was Molly at the time, made her aware that we were going to go into the unit, repair the unit. I had actually called the engineer, had him come down, went through a scope of what needed to be done, and he drafted a set of plans. We filed them, and during that time, there was some changes that were made to the scope due to digging into the property and finding out what was problems or future or existing problems and needing to fix certain things. We went back and revised it, and Molly actually had stopped by to visit the property and then started taking pictures and realized that she was actually going, she told me she was going to file a notice of violation. I made her aware that I felt that because we had hurricane damage and we filed a permit, that there wasn't the right to actually file violation. I made her on notice. She didn't tell me to stop. She told me to get a permit in, which I did. And I moved quite quickly with the engineer to get it in. I think we're within, 3 weeks of the time that we actually opened the building up to discover what was actually underneath the layers of the problems to the time I actually filed the permit. And from that point, I actually brought the engineer into the town to meet the plan reviewers at that time. I'll tell you that the staff at that time is not the existing staff that we have today. The staff that we have today is actually much better at processing a permit than that staff was. The engineer I had come down here probably 2 or 3 times to sit with staff to figure out how to issue that permit. They went through it several times. It was difficult with that engineer, getting him to deal with what they wanted and what the requests were. It took about 3 trips to make that work, and it finally was issued.
Problem was that there was work done before that permit was issued. And I understand that it was trying to remedy matters from Hurricane Irma. That still does not provide an excuse for anybody doing work without a permit. I understand emergency situations, but even under those scenarios, the requirement is to notify the building department within 24 hours to go ahead and obtain the necessary permits.
I did notify the town. I actually came straight to the town
there was
before
work being done without permits on a commercial property.
I actually notified the town before we commenced any work.
Madam Special Magistrate, the printout that we provided to you, and that I think that in the file or in the materials provided by Ms. Grady is also referenced in there, is our Trackit, our database. There were 29 comments. Not all of them rejections, but the vast majority of those rejections of the plans that were submitted. And that's the reason why there was delay. Plus, at the very end, there was a substitution of contractor. Mr. Orlandini was not the original contractor on this project. That required additional time and review by staff. So there were, a long history of back and forth and incomplete plans that delayed the issuance of the permit during that time frame that they said. And in the meantime, work is taking place and outside the scope of what actually had been permitted. And so that's why the repeat violation was issued. Again, notwithstanding what the attempt to go back and what I would say relitigate or re-argue the hearing, that's what the record is. And as you stated, Madam Magistrate, is the fine is still at the 250, which is the upper end of the first violation. And we, as staff, believe that, again, we followed the code, we followed the state statute. That fine was imposed. It can't be collaterally attacked at this point in time. It's improper. There's already a determination that that's the appropriate fine based upon the criteria that's in the code and in the statute, and that's the amount that the magistrate should apply to the requested lien request.
Hans, if any?
Yes. One, we're not attacking the original finding, but we are requesting, and it is appropriate, and the special magistrate has the ability to take into account and look at the overview and listen to what has been presented, and that, and to reduce a fine from a $250 a day, which is punitive. We're not attacking anyone. We're just saying if you look at other code violations for work without permit, this is the maximum that has been assessed, whereas the similar situations are assessed at a lower fine. And we were asking that once the permit is issued, to at least recognize from that day forward all the work that takes place when the permit encompassed what it did. It was issued, and all the work that took place so we could finally get the final inspection and close it in June of 2019. All of that is legal work, and you shouldn't be assessed at $250 a day once you have the permit and everything you're doing is legal. We think it should be substantially reduced from that, and we would request that.
Before I issue my order regarding the request for certification, I'm going to advise both parties that I'm perfectly fine with the $250 per day. Had I been the magistrate at that time, that's exactly the amount that it would have been for a first-time violator, as we take very seriously work being done without a permit, especially in a commercial property where you have patrons and you have people coming in. So the $250 per day would have been exactly what I would have assessed, and the request for the daily fine to be reduced is, I'm going to deny that. However, I do concur with the respondent in regards to the calculation of days. The statute regarding the violations relating to work being done without the permit only requires the issuance of the permit, which in this particular case, the evidence presented shows that it was issued on August 28, 2018. Therefore, the fines, the appropriate fines would be from the compliance date of July 18, 2018 to August 20th of 2018. So I find that the order of the magistrates, to the extent that it required for the inspections to also take place within that time frame, was inappropriate, because that's not what the code requires. So if we have that number. By any chance?
So the date it was issued?
Yes,
what
it
you're
would be
saying?
from July 18th of 2018 to August 28th of
28.
2018. I think that's 30 days. But I'm not very good at math, so.
We're doing it. $41 days.
41 times the 250. 41,
July 18th,
yeah.
correct, to
August 28th.
28.
Oh, yeah.
28.
Yeah,
Yeah.
30 days.
Okay.
Got it.
41
See, I'm telling you the math.
250 is $10,250.
That order included $300 in admin fees and cost.
$1,550.
Now in compliance by virtue of the issuance of the order, correct?
Pardon?
The
It is.
Yes,
property
it is.
Okay. So if you're hereby find that the magistrate's order dated May 31st of 2018 was not complied with within the time frame stated therein. However, I do find that the magistrate's order dated May 31st of 2018 incorrectly required the respondent to also do all necessary inspections by July 18th of 2018, when the code only requires the obtaining of a permit, at least in the way that the notice of violation was stated. Accordingly, the property was out of compliance for a total of 41 days at the rate of $250 a day, equaling a total of $10,250. Pursuant to the magistrate's order, there was also the addition of $300 in fees and costs, bringing it to a total of $10,550, which I hereby certify said order in that amount, $10,550. The property is in compliance, therefore fines will not continue to accrue. But by certifying this order, it will become a lien against the property, which shall be recorded in the property records, in the official records of Lee County, Florida. All right, thank you.
Special Magistrate, I know we still have a lot to get through, but can we take maybe a 10-minute break?
Of course.
Okay.
Madam Magistrate, it appears you just skipped over.
This is, I don't call the cases, they do, so.
Why did we skip over my case?
We took them in order of
I took them in order that they were signed up on the
Yeah.
thing. So I took them in order that they actually
Which
physically
is the way we always
appeared.
do it, that's
Yeah.
fine, I don't have a problem with that. All right, so we'll adjourn, we'll take a little break.
Yeah.
Thank you.
Thank you.
That's after the 10-minute break. So you're going to be like. Okay, here's what I'm going to do. I will continue that for you two, and then we'll talk to you about. Yeah, okay. So this is what I'm going to do, is that I'll talk to you about yours. I've got your email. We'll continue this too, so you can leave. And so then I'll contact you, and then we're gonna go over all 4 of your cases. Right, yeah. Okay. Thank you so much. Uh-huh. Who was next?
I'm just asking where I am.
Here's what happens, is that what was your name?
It's Doc Home Properties or.
Okay, Doc Home. So you're gonna have 2 cases, and then I'm gonna start going by the order that there is. So I can't really, we haven't forgot you.
Scheduled this afternoon,
Yeah.
Cancel.
Well, I can't, this is the way it works.
Okay.
Yeah, so, yeah.
How many you think are coming?
All right, there's gonna be 2, and then there the 2 attorneys that are gonna come up, and then then we go into the number 10 suit is gonna be, and then Andrew.
I'm the code enforcement officer.
Are you familiar with case 2019-1220, violator or alleged violator on-site water sport rentals LLC?
Yes, I am.
Can you please tell the special magistrate how you are familiar with this case?
We got numerous complaints about on-site water sport is conducting business in town of Fort Myers Beach with their.
I'm going to have to inject his hearsay. He's talking about what other people are telling him.
Also, the rules are very informal when it comes to evidence. They're allowed to testify regarding hearsay. Proceed.
We got numerous complaints about on-site water sport conducting business within the town of Fort Myers Beach with their jet ski rental. Upon further investigation, I called the company to get more information about it, just to see if I can understand the business plan and how they're doing things. And then what I gathered so far is that they are renting jet skis in the town, based off what the complaints that we have and what I gathered so far. And so I contacted the on-site water sport to let them know, hey, you guys are in violation based off the town's ordinance. And the ordinance states that no person shall conduct any personal watercraft rental business within the town of Fort Myers Beach except for any business holding a valid PWVL license. I'll let him know the violation, what it means to the town and his business and how he can correct the violation, which I told him that in order to correct this, to stop conducting business or renting your jet skis to beachgoers in town. So that's.
Officer Lee, is that this code section 27-49?
I'm sorry, excuse me. I didn't hear what he said when he said the correction part. If you might just ask him to repeat it for me, please.
I believe he said cease operations, obtain a PWL license, but I'll.
Yeah.
Cease
Please.
operations.
Yeah, to cease operations.
Why does the property owner have to cease operations, Officer Lee, based upon your knowledge of the code?
But the town ordinance, in order to conduct business with a, with a jet ski, you need a PWVL permit. And our records indicate they don't have a PWVL permit with the town of Fort Myers Beach to conduct their jet ski business.
Does the town code require a physical presence in the town in order to have what you've stated as a PWVL license, which is a personal watercraft vessel license, I believe is the.
Yeah, that's correct.
Okay. In the materials that in your in the file, did you take any pictures or download any information regarding this operation?
Yes, what I gathered so far is from their social media, Facebook. You can see on the PowerPoint, where they're, stating that, they're having jet skis going to Fort Myers Beach. Some reviews said that they rented a jet ski from a company in Fort Myers Beach. Also complaints from other people on the beach, and they've seen their jet skis out there. And as I recall, they don't have a permit to conduct such business on the town of Fort Myers Beach. And so, of course, and they also had got a warning from Lee County in regards to their business. And it states that as amended section 4, unlicensed rental of personal watercraft, cease rentals until PWVL is obtained. And as I recall, they don't have a PWVL with Lee County or the town of Fort Myers Beach for the business that they're doing here.
In your review of On-Site Water Sport Rentals LLC's Facebook page, do they specifically identify Fort Myers Beach as an area where they provide rentals?
Yes, they said customers will ride through Fort Myers Beach, Sunnyvale, and St. James City on their free-range ride. And they also promoted that they're renting jet skis for Roar Offshore that happened several weeks ago or a month ago.
And that event was here in Fort Myers Beach for Roar Offshore?
That's correct.
Okay. Nothing further this time. We'd move into the record the notice of violation, notice of hearing that was issued to the business owner, the certified mail receipt that was received indicating that the registered agent for On-Site Water Sports did in fact accept the notice of violation, notice of hearing, as well as the phone captures from Facebook that Officer Lee just testified to. Did you verify prior to issuing the notice of violation, notice of hearing, who the registered agent for on-site water sports rentals was?
Yes.
And how did you determine that?
Visual
Now,
corporations.
hang on, Judge. I got to object. We got a clerk here
That's
literally
correct. Hold on,
saying the
hold on.
answers for the witness to
That's-
repeat.
and-
Sir, let me finish my objection. I object, Judge. That's clearly improper.
I'm going to give the witness a copy of the state of Florida.
Understand, sir, that's not my objection.
I
My
understand.
objection is that the clerk is specifically speaking the answers that the witness is parroting, Judge. Who's testifying?
I'm gonna allow the objection and allow him to go
And
ahead
I'm
and
going
present the document and
to
allow
cure the objection.
and allow the witness to testify.
Officer Lee, do you recognize that?
Yes, I do.
What is that?
This is the name of limited liability company, Onsite Westward LLC, with the Lee County. I'm sorry, give me a second. I'm sorry, give me 1 second. It's a personal business license with Onsite Water Sport. I'm sorry.
I'm going to show you a copy of a printout from the Division of Corporation, State of Florida. Recognize that?
Yes, I do.
What is that?
This is the registration of the business with the Division of Corporation, State of Florida.
And who does it state is the registered agent?
On-site registered agent, it is Sousa Santiago.
Is that who the notice of violation, notice of hearing was sent to?
Correct.
Nothing further. We move the file into evidence.
All right, counsel?
I object to that being admitted into evidence. It's hearsay, it's not authenticated, but more importantly, I need to see an actual legible copy of that warning ticket. I haven't seen the rest of it, so I'd like to see it before it gets moved into evidence.
Your objection regarding hearsay is overruled. However, you are entitled to go ahead and see the documents.
This is the entire file that's being moved in, sir?
No, I'm sorry. You wanted to see the entire file? Yes.
I
We'll
haven't
show to
seen
you.
it at all, I apologize.
Sure.
My name is Mike Chinopoulos, and with me is Attorney Iris Padron. We represent the respondents, the defendants in this matter. Mr. Lee, were you the person who gave this warning
Yes, that's correct.
on the 18th day of October?
Wants you to repeat the question.
Sir, you were the code enforcement officer that gave this code enforcement license investigation warning we have here in your file, right? The one that was up on screen?
Yes, that's correct.
Okay. And where was it that you gave that warning, sir? Physically, geographically, where were you?
Here in my office, where I gave the warning, I gave a verbal warning over the phone, and then I notified on-site Westport that they receive a mail about the violation for their records, and so they can have it for their copy as far as the ordinance and what it means.
And, sir, exactly where did where did my client do business within the town of Fort Myers Beach?
Where did he do business? That's what you asked?
That's, as I understand it, sir, that's why he's here, because it's alleged he did business in Fort Myers Beach without a personal watercraft license. Is that correct?
That's correct.
Okay, so where was it in Fort Myers Beach that he did business, sir?
We got numerous complaints saying that they seen his jet skis out in the Fort Myers Beach. Also, his Facebook post shows that he has beachgoers ride the jet skis, his jet skis, or on-site Westport jet skis on Fort Myers Beach.
And are they, when you say on the beach, sir, are they actually like beached up on the beach?
Yes, like the beach, yeah.
And you've personally seen his watercraft beached up on the beach, sir?
Personally, I have not seen it, but there has been.
Okay, so you're telling us what somebody else has told you? Yes?
Correct.
Okay. And there were pictures and other things, sir. Is there any evidence that my client's watercraft were up on the beach?
I don't have the personal pictures showing that, but as I recall that there had been complaints saying they seen him, and not him personally, but beachgoers with his jet skis on the beach without a PWVL license.
Okay, so as we stand here today, is there any evidence, pictures, personal knowledge, any evidence that you can present that my client was doing business on Fort Myers Beach?
No, just the screenshots.
The screenshots of?
Facebook, of the On-Site World Sports Facebook page.
Okay. So can we agree that the City of Fort Myers Beach Authority, according to the code, stops at the mean high water, sir?
No.
I'm sorry, are you testifying, sir?
No, I'm objecting to the question
Oh, I
asked for
didn't hear
legal
objection.
conclusion. If he has evidence that the city's jurisdiction ends at the mean high water line, he certainly can introduce that evidence into the record.
Well, see, Judge, that's the thing. On cross-examination, I was under the misimpression that I got to ask the questions and find out what the witness knows.
No, you can go ahead and ask the questions. We can object, counsel.
Sir, now that you've been told the answer, would you like to tell me what the answer to my question is?
Can you repeat the question, please?
Is it your understanding that the city's jurisdiction ends at the high mean water mark with respect to the Gulf of Mexico, sir?
Not to my knowledge, I don't know the answer.
Okay, so where does the city's jurisdiction end?
Object.
I
You have an
object.
objection.
More.
You're looking at me like you have an
Thanks for
objection,
helping him
object.
practice law, Judge.
I mean, what I was going to do is, the city's jurisdiction is a matter of public record.
Judge, I'd like to hear an objection. That's a speaking objection. He's just telling us what he wants us to hear. What's the objection?
The objection is it asks for a legal conclusion.
Okay.
In terms of the request for a legal conclusion, I sustain the objection. However, I believe the question was posed as, did he personally know
Right.
where it was? If he does, he does. If he doesn't, he doesn't.
No, I don't know, sorry.
So, sir, you don't know where the city's jurisdiction ends, do you?
To my knowledge, I believe the city jurisdiction is from island to island, so from the north end to the south end of the island, from beach to beach.
And that's the jurisdiction of the city of Fort Myers Beach, sir?
Objection. Ask for a legal conclusion.
Yeah, as his understanding.
Repeat the question.
Well, you just stated that the jurisdiction of the city goes end to end from the island. I'm asking you to confirm that's your understanding of what Fort Myers Beach jurisdiction is.
Objection asked and answered.
He can answer, and it's your
Yeah,
knowledge.
that's my understanding.
Okay. Now, isn't it true, sir, you're responsible as a code enforcement officer for enforcing the code of Fort Myers Beach?
That's correct.
Okay. And isn't it true, sir, that it would be reasonable to expect one enforcing a code to know its jurisdictional limits?
That's correct.
Okay. Sir, you haven't been a code enforcement officer very long, have you?
Started in July.
Started in July. And you played at the Oklahoma City Thunder, didn't you, sir?
Objection. Relevancy.
Sustained.
Okay. Sir, are you familiar with the Code of Federal Regulations? Do you know what those are?
Repeat the question, I'm sorry.
Are you familiar with the Code of Federal Regulations? Do you know what those are?
Objection. There's no predicate been laid as to the relevancy of this line of this question.
Judge, if you'll allow me a little leeway here, the Code of Federal Regulations actually supplement the city code from a legal analysis position.
I would, again, object. There's absolutely no evidence or any predicate laid to such a fact.
Can't lay it without asking the questions, Judge.
I'm gonna give you a little bit of leeway. I have an idea of where you're going, but make it quick.
Sir, my question is, do you know what the Code of Federal Regulations is?
No, I do not.
Okay. That was it, Judge. That was easy, right? Now, you said something about offshore in your direct testimony. My client advertised offshore rides or something?
Repeat that, I'm sorry.
In your direct testimony, sir, you said something about offshore rides, that my client directed them or advertised them or something?
Sir, objection. There's no question been asked.
I'm asking him to tell me what he said on direct. I don't remember exactly what he said, and I want to ask him follow-up questions. Sir, did you say on direct examination that my client took people on offshore rides?
If that's what you said, it's a yes. If that's not what you said,
I don't
it's a no.
recall. I can't remember if I said that or not.
All right, well, Judge, is there a record we're going to need to read back so I can cross-examine this gentleman?
Not unless you brought one.
Okay. Happily, my phone's on record. I guess we'll go through it later. Sir, do you have any knowledge of my client directing offshore rides?
No, I do not. Only from complaints from various people and the evidence I gathered.
And so this is just something people told you?
Complaints and doing my own investigative research on the social media of on-site water sport.
Well, now let's talk about those complaints, sir. From whom did they come?
It came from beach vendors on the beach, the town of Fort Myers Beach.
Oh, you mean my client's competitors?
If that's what you want to state, yes.
Okay, didn't come from any non-business owners, though, did it, sir?
Not to my knowledge.
No. It's kind of funny. In fact, sir, isn't one of the complainants also a council member on this very city board?
Objection.
Oh,
Relevancy.
I got relevance all over that under 401 and 403, Judge.
I'm going to sustain the objection.
All right, sir, list the complainants.
It's the complainants.
Yeah.
One complaint is a beach vendor on town of Fort Myers Beach.
So, sir, was Sharon Faircloth one of the complainers?
Yes, that's correct.
Okay, and she's a member of the city council, isn't she, sir?
No.
Oh, I'm sorry, she's not. Was Joanne Champ one of the complainers, sir?
Not to my knowledge.
No. Did you ever speak to Ms. Shamp during this investigation?
No, I haven't.
So you've never had an email from Ms. Shamp about this very matter that we're here about today with respect to on-site water sports?
I guess you're confusing if I had a personal conversation with Shannon and if I have got an email from her. I'm sorry, Ms. Shamp, compared to if I got an email from her. I know I have not had a personal conversation with Ms. Shamp about this matter. I received the email, complaints, and then I investigated the violation in the business.
Okay, but my question's more specific than that, sir. Is it your testimony here today under oath that you have never received an email from Ms. Joanne Shamp regarding my clients and this very matter of enforcement? Is that your testimony here under oath, sir?
Yes, I may have received an email from Ms. Shamp, but I don't have it right here.
And did you provide that to the city attorney, sir? Would have been part of your file that you turned over, right?
Can you read that?
I said that email would have been part of your file that you turned over to the city attorney, wouldn't it, sir?
Correct.
Sir, I don't see it in the file here today that I'm looking through. What do you make of that?
Simple human error. Apologize.
Can you recall what that email says, sir?
Unfortunately, I cannot.
Oh, goodness. So, sir, do you have any pictures of my client's water sport vehicles on Fort Myers Beach?
No, I do not.
The place you gave them the warning was not on Fort Myers Beach, correct?
Correct.
Okay. Sir, isn't it true that to conduct business on Fort Myers Beach, you have to conduct a transaction there?
Objection. Ask for legal conclusion.
Well, now, wait a minute, Judge. My response to that is, read what this man wrote for correction. He's interpreting the code at that specific portion of the code. If he wants to interpret it in a warning, he's got to stand for it in court.
I'm going to sustain it to the extent that it recalls for a legal conclusion. However, you can ask him whether he personally knows.
Approach the witness, Your Honor.
We may. Try to counsel whatever you're showing him.
It's from.
Oh, okay, perfect.
Who marked this?
This is your copy right here that I've handed.
Oh, okay, okay,
So
I have a copy.
it has no marking.
okay.
All right, sir, I've handed you a document. Would you look at that document with me, please? No. And would you identify?
Sorry, can you repeat that? Can you hear you?
Sir, would you look at the document I gave you?
Yes, I'm looking at it.
And please identify that document.
It is a combo sent by the town of Fort Myers Beach.
And who signed that document, sir?
I signed that document.
Okay, so you wrote this document.
That's correct.
So you wrote on page 1, the 4th paragraph there, starting with the violations. Can you read that paragraph aloud, sir?
Objection. The document speaks for itself.
We're on the notice of violation?
Yes.
Okay.
It's the violation for which my client's here today, Judge.
Go ahead and read it.
All right. As it states, the violations can be brought to compliance by taking the following actions. Immediate stop conducting personal watercraft business within the town of Fort Myers Beach, must have a PWVL license to operate business within the town.
Okay, and what does immediately stop conducting personal watercraft business within the town of Fort Myers Beach mean to you?
It means that in order to conduct business, you need a PWVL license for any watercraft vehicle.
Oh, and I'm a little confused. Where did you get that language from? Immediately stop conducting through the rest of that sentence. Where did you get that language from, sir?
My personal language, because as I recall, you need a PWVL license to conduct business within the town of Fort Myers Beach. So until you obtain a PWVL license, you cannot conduct business within the town.
My client rent any watercraft?
Personally, no.
Okay. Do you have any evidence here with you today that shows he rented a watercraft?
That your client rented a watercraft or customers?
That he leased a watercraft to anyone?
Not personally, just only Facebook reviews, Facebook posts and things of that nature, and investigating complaints.
So when we look at that Facebook post, sir, I mean, let's go through them. Let's just take your Facebook post and go through them. May I approach the witness, Your Honor? Posts that were taken out of your own file, sir. Would you take a moment to look at those and identify which one shows that the customer rented that water sport vehicle on Fort Myers Beach, in the town of Fort Myers Beach?
See one with one of the reviews. It states, if I'm.
Let me look at it with you, sir.
Oh, sorry, here you go.
We'll look at it together.
Okay. At it states, one of the reviews said, I had one of the best times at Fort Myers Beach. I called on-site water source because Fort Myers Beach rentals were expensive and only for a few hours. I wanted to ride all day with my friends. On-site delivered the jet skis to me with vests and everything needed. They were the nicest people and asked any questions we needed answered. We rode all day for about 7 hours. It was a great time and affordable. I won't call anyone else to rent.
Now, where does it say that she rented these from him on Fort Myers Beach?
Thought it clearly states it right there. I had one of the best times on Fort Myers Beach. I think as it alluded to.
Okay. So who is this person, sir?
One of the reviewers.
Who is this person, sir?
I'm sorry. Procedurally, we need you to stay with the microphone so we can pick up the recording.
I got it. I'm sorry.
So I'm sorry to interrupt.
No, that's all right. So, Mr. Lee, who is this person here that you've just read the quote from?
It's the one.
Objection asked and answered.
Well, it was asked, Judge, 3 times. It just didn't answer over opposing
He's
counsel.
answered that.
Yeah.
Well, I didn't hear him. What was the answer?
A Facebook reviewer.
Oh, okay, I didn't hear that. And do you know that person's name, sir?
I don't know that person personally at all. Don't know him or
Okay.
she.
So then is it safe for us to assume you didn't talk to this person, sir?
No, not personally.
Okay. And so where did this come from? This piece that you just read that's in your file?
On-site water sports Facebook page.
Okay. And what date was that?
Does not say because the screenshot of the phone.
So we don't know what date this was taken, allegedly, right?
That's correct.
We don't know what time it was taken.
Not from what I have in front of me.
Okay. We don't know who this poster is, right?
Could you read that?
We don't know who the person posting is.
Says it right.
Objection asked and answered.
Okay. And, sir, have you ever read Google reviews?
Objection, relevance.
Well, the relevance is, Judge, that he obviously uses Facebook to conduct part of his investigation. It is reasonable to believe that he uses other forms of social media. It's clearly relevant to what information he has or doesn't have about my client.
What's before in the case file and what has been presented is regarding to the Facebook postings. If you have something different from Google, please go ahead and present it to council, and I'll rule on it.
If I may, the testimony that the town has presented is regarding the Facebook postings of the business owner.
Agree.
Nothing more.
I agree.
Okay, so just so I understand, the Facebook posts don't open the door to social media. That's the court's ruling.
Also, what has been presented has been the Facebook postings. If you have something from Google that you would like to use for impeachment purposes, be my guest. But right now, we can't just go on speculatives because we're going to start with Google and then Bing and then Yahoo, and where is it going to end?
That's up to you, Your Honor. So, sir, isn't it true that anybody could have posted this on that Facebook page?
Objection. Calls for speculation.
Well, sir, if we don't know who it is, doesn't it stand to reason that it could be anybody?
And what the witness has testified that he does not know who the poster is. If there's
So I agree, we gotta move on.
Okay. So, sir, can you say for certain that this was not one of his competitors posting on the webpage? Can you say that with certainty, sir?
I cannot say that for certain.
So that it's possible, correct?
objection, calls for speculation.
Sustained.
And sir, you've seen people post nasty stuff on other people before in your investigation simply to gain a social media standpoint, right?
Objection. Assumes facts not in evidence, not relevant.
I'm asking him what he knows as an investigator, Judge.
It's not relevant.
Okay. One more note. That was one more note. Yeah. Sir, if my client rents jet skis, and those jet skis go offshore, I'm still confused. I heard the word offshore in your testimony, and it bothers me. Were you offering the opinion that if my client rents jet skis and they go offshore, that somehow violates the town of Fort Myers Beach municipal code?
Objection. It assumes facts not in evidence. We don't, the absence of a record, and it's improper foundation as a result.
Sustained, and I believe it misconstrues what he stated before.
All right, well, let me ask you this, sir. What does offshore mean to you?
Objection.
Is the word offshore on the table? I don't believe it was.
What we're here for is for a violation of 27-49.
Well, can we stipulate that anything having to do with offshore is not a violation for purpose of this hearing? Then I won't have to explore it.
No. No, we can't.
Well, then,
Because
Judge,
I'm
I got to
going
be allowed
address that
to
issue on
question the
rebuttal.
witness about that issue. I mean, you can't deny me constitutional cross-examination, Judge. Now we're talking about 14th Amendment due process.
So you did open the door, counsel.
Okay. I mean, as long as as the special magistrate allows me on a rebuttal to
Absolutely.
address that
If he
issue.
brings it up and you've conceded that
Oh,
you're
it's
not
already
on the
clear. You
table,
can do whatever you
you'll-
want here. Don't worry about that.
You'll rebuttal. Go ahead. You may proceed.
Sir, what do the words offshore mean to you?
Personally, I believe offshore means, on the water outside from the sand, the beach, offshore.
Okay, does it have a length to it in your mind? If I say offshore, can that be 6 inches or can that be 60 miles?
Again, objection.
I'm asking him what he thinks it is, Judge.
It's
He's
his personal knowledge.
testified
You open the
of-
door. You open the door to the offshore.
But I'll stipulate to a standing objection for my entire line of questioning, counsel, if it'll help.
Sorry, repeat the question?
What does it mean to you? Does it mean 6 inches offshore? Does it mean 60 miles offshore?
I don't have an answer to that.
You don't have an answer to that?
No.
Okay. So in your definition of offshore, is it possible for somebody to be in violation of any provision of the Fort Myers Beach Code as you understand it?
Objection.
When a judge, he's testified that my client violated the code.
No, but your question
can he now
was
say-
very open-ended. It's like, your question was very open-ended. I believe here, the issue in this case is whether your clients were conducting business in the town of Fort Myers.
Well, may I have leave to ask the witness hypotheticals, Judge?
If you're asking him to speculate.
Well, and
we're
that's why I'm
here on
asking for leave.
we're here on a very concrete set of facts. And there's no reason for there to be speculation entered into the presentation of the case, because I'm not going to be ruling on speculations. I'm going to be ruling on what the ordinance says, what code says, and what the facts of the case as presented say.
Judge, my problem is the witness testified on direct about offshore. I didn't get that. I asked him to explain it to me. He's not been allowed to. Now I'm trying to seek offshore. I've asked that the city stipulate that whatever that offshore thing is not a violation for today. They refuse to do that. I mean, I have to explore what was the witness talking about with offshore, and does he think that's a violation? Let me just ask you this, sir. Is any allegation that we're here about today, does it have to do with any offshore activity?
We're here today is about conducting business within the town of Fort Myers Beach without a PWVL license.
Does it have anything to do with any offshore activity as you understand the meaning of the word personally, sir?
Repeat that?
Does today's hearing have anything to do with offshore activity as you understand the meaning of the word?
As I stated before, we are here to talk about a PWVL license that has not been obtained from the town of Fort Myers Beach.
Okay. Your Honor, I'd ask that you strike the witness's answer and ask him to answer the question. The question is, as he understands it, do any of today's allegations contain any offshore allegations?
Answer the question.
Not to my knowledge.
Okay. Well, I have nothing further on cross, Judge, but I do reserve the right to rebuttal cross if necessary.
Officer Lee, based upon your investigation, has it been your determination that On-Site Water Sport Rentals LLC is in violation of Section 27-4919 of the Town Code?
That's correct.
Further.
Did you say nothing further?
Yeah, he said nothing further.
I just have one follow-up, Judge.
Go ahead.
It's your opinion that water sports is in violation. What specific activities, actions, dates, and times do you allege you are using to support your opinion, sir?
Objection asked and answered. That was the city's case in chief.
Well, then it was,
And he had an opportunity to
Judge, then his
cross-examine.
rebuttal was asked and answered too. So, I mean, I guess the rules are good for one, they got to be good for both, right?
I'll allow him to briefly answer the question.
Repeat the question.
The specific incidences upon which you rely to state your opinion that my client is in breach of the code or in violation of the code.
Is there a question? Something more like a comment?
I'm asking him, sir, that I'd like you to tell me the specific instances upon which you rely to form your opinion that my client was in violation of the code. So the dates, times, and places of each occurrence you allege support that opinion.
Investigating numerous complaints.
I'm sorry, I can't understand you.
Investigating numerous complaints. Talking with the on-site water sport manager or business owner about the violation, how they can be in violation based off their business model, and also doing research on Facebook, screenshots, and further investigation with Lee County, and a warning been previously cited for the business model that on-site water sport has. And the warning also indicates that you got the companies a PWVL license to do what they're doing, and also just the Facebook reviews,
Okay.
as I read earlier.
Okay. Just one more. You've never worked for you said the Facebook reviews and all that. You've never worked for Lee County Sheriff's Department, have you, sir?
No.
And there's no memorandum of exchanging jurisdiction that you know of for your code enforcement authorities to extend into Lee County, or is there?
Not to my knowledge.
Okay, thank you. Nothing further.
Brother? Okay. I hereby find that the violations as stated in the notice of
Well,
violation.
Judge, we didn't have our chance to put on a case. We get our case,
Oh.
right? We get our defense.
You're going with all the formalities of that. Go
I mean,
ahead.
you just want to get
That's
to the
why
hanging.
I'm heading-
We got to
I'm-
get through the fair trial before we get to the hanging, Judge.
Go ahead. Normally, when we do
Are you
these, that
kidding me right
they're-
now, really?
They're a lot less formal than, I understand you're a trial attorney, and that things are done in the trial court a little different than they're here. So once you concluded with that, I thought you were done with your case in chief. Please proceed if you have witnesses.
Well, the first thing I'm going to do, Judge, is demur the evidence. They presented no evidence that my client has ever even set foot, other than today, within the town of Fort Myers Beach. There's certainly no evidence that he's ever even drug a jet ski into the town of Fort Myers Beach jurisdiction. Where they cited him, and not only that, Judge, but they've specifically lied to you. This witness stood up here and said he issued that warning. Look at that warning, Judge. That's not him, and he didn't work for Lee County. He lied to you under oath. They specifically took evidence and withheld evidence, prosecutorial misconduct. He testified that he gave the state's attorney that email, and it's now missing, Judge, and it's exculpatory to my client. These people are playing games, the same reason that we couldn't get called on the docket this morning, Judge. So I'm moving for a demur to the evidence. They have no evidence, and you have no subject matter jurisdiction as a result of him never setting foot on this place.
All right, the request is denied. Is there anything further you would like to add?
I can go on with my case now.
Okay, well, proceed.
Come on up, sir. Please state your name for the record.
I don't, did they take an oath? I don't think they were sworn in.
I was here in the beginning.
Okay, I thought the lady with the blonde hair was, okay, yeah, okay, proceed.
Paul Shoddy, owner, On-Site Water Sports.
Sir, when did you form On-Site Water Sports?
About 6 months ago.
And where is On-Site Water Sports located, sir?
It's ran out of our home, 4116 Wilmot Place, Fort Myers, Florida, within the city.
Okay. And
Yeah.
Within the city of Fort Myers.
have you ever conducted business within the city of Fort Myers Beach?
No.
Okay. Sir, what kind of vehicle do you use to conduct your business?
I use a Dodge Ram pickup truck, 4-place trailer.
And what ramp here in the town of Fort Myers Beach can you get that truck into, sir?
The short answer is no. Reason is Fort Myers Beach does not have a boat ramp for us to use. From bridge to bridge, there is no boat ramp for us to utilize.
So how would you, okay, well, never mind. Can we say then that you have not launched a jet ski for commercial purposes from the town of Fort Myers Beach?
Correct.
All right. Where have you launched those vehicles, sir?
We utilize Lover's Key with permission from code enforcement to do so. We also utilize other boat ramps, the Oasis boat ramp downtown Fort Myers, which we hold business tax receipts in.
Have you ever used Punta Rasa?
We have.
All right. Counsel, this came out of your... I've handed to opposing counsel a copy of a map that came from his own file. Sent to the client by now. Is that correct, sir? Do you have any objection to me using that?
No.
I'm handing you a copy of a document. Would you please identify that document?
This is a document of the map of Lee County. It shows the unincorporated parts of Lee County and the incorporated parts of Lee County.
And from where did it come?
It came from the lee.gov website.
Oh, okay. And let's see, they have a key here that says the town of Fort Myers Beach. And when you look on that map, you see the town of Fort Myers Beach in that shaded color?
Yes.
Okay. And point out on the map each area within Fort Myers Beach that you have collected money for the rental of jet skis?
There has not been.
Point out on that map any place that you have dropped jet skis in the water for commercial use.
There has not been.
I want this. I want this. Do you have what they've referred to here as a PWVL, which I understand means Personal Watercraft Vendor's License?
No.
Why not, sir?
They did away with it back in the late 90s. Anyone who previously had it before the 90s were grandfathered into the law. Since then, when the town of Fort Myers Beach became incorporated on December 31st, 1995, it was about a year or two later that you guys enacted the PWVL with all the current vendors grandfathered into the clause, at which point the following years were changed by the vendors of Fort Myers Beach. They control how many licenses are distributed, and they control the laws and the regulations pertaining to them.
Have you ever, for commercial purposes, navigated or otherwise used any vessel in or under the water at Fort Myers Beach?
No.
Now, how do you control where the people leasing your watercraft go, sir?
No.
I need you to speak into the mic. We have to share one.
We don't.
I love you, man. Well, how is that possible? You have GPS on them? I mean, how
Yes,
does that?
we do. All of our jet skis are Argo tracked. For those who don't know what that is, they are GPS. We know where they are at all times. We also offer free range riding. Our jet skiers are able to take our jet skis and go throughout the waterways in which they choose.
Not everybody does their jet skis on what I call free range riding. Is that true?
Nobody does.
Do you know of any vendors on Fort Myers Beach that do that?
No, sir.
And what's your belief or your understanding or your thought as a businessman as to why nobody would compete with you and do the same thing?
It is only my understanding, my knowledge, that in order to abide by the town and city of Fort Myers Beach guidelines, is you have to own property to be able to, operate a jet ski business. Those properties are assumed as hotels, motels, so on and so forth. It is only my understanding that there would be insurance liabilities that would keep jet ski companies from allowing their customers or renters to go out of line of sight. The other factor is insurance. There's only 3 companies in the state of Florida that will give insurance to jet ski companies. There's only 1 company that will allow free range riding, and we hold that license.
So it's completely within your insurance policy to let them free range ride?
Correct.
Special Magistrate, I'm going to object to this line of questioning. It's relevant.
I sustained. I was wondering
What's
how
the
long that was
relevance
gonna take you.
to the matter before you?
We've established that through his testimony that he's never been on Fort Myers Beach or rented on Fort Myers Beach. Now we have to establish the radius of his vehicles, Judge.
Ask him that.
Well, I'm getting there.
I
I'm
think-
sorry that I don't practice law the way you do, Counselor.
I proceed with the questioning. Just try to limit it. We have still people in the audience. I'm sure they want to get home or to their jobs, and this is taking a little too long.
Well, I'd like to get off my broken leg too, but since you wanted to rule before my case even started, I figure I got a little mountain to climb there,
Also,
Judge.
it's very unusual for somebody to go ahead and make argument against the town's presentation and not put their own witnesses at the stand at the same time to go ahead and do this ruling in these types of hearings. That's the reason that they are not as formal as court proceedings. The rules are less formal, and we try to move them along, hence the amount of people that we have in the audience waiting to have their cases heard.
So the Constitution's on vacation.
Nobody said the Constitution is
Oh,
on
all right.
vacation. In fact, I'm actually allowing you to present your case in chief. However, you're taking a little long on matters that are not relevant, so I'm asking you to please step it up, especially for the benefit of those who are still here.
Sir, have you ever rented a car before?
Of course I have.
Where'd you drive to? Sanibel, Fort Myers Beach?
Miami, Tampa, out of state.
Council's not
So-
objecting to it. Car rentals are not relevant. Please try to keep it tailored to what is this case is about.
Yeah, it's called a parity, right? So you get to compare to do an analysis.
Council,
Right,
please,
so,
please
sir-
stick to the facts of the case. We've been on this case now probably close to an hour. Let's move it along, please.
Sir, in your opinion as a businessman, if somebody rents a watercraft, a vehicle, a vessel, any type, and comes onto Fort Myers Beach, does that mean the person who rented it to them is doing business on Fort Myers Beach?
Objection. Ask for a legal conclusion.
Yeah, as for his opinion,
I think he
Judge.
did ask for opinion.
My opinion is no.
Why not?
I have no control over it, just like with the rental car. They have no control where I take it.
Well, now just logically with me, as a businessman, do you get concerned about things like permits and taxes, or do you just blow that off?
No, I'm absolutely concerned, and I'm actually absolutely in line with everything.
Okay? So, as a businessman, if you're thinking your vehicles may be someplace, does that mean, gosh, all the bicycle rental companies, the kayak renting companies, the sailboard renting companies, wouldn't then everybody have to have a license?
They would, and pertinent to what we're here for, I would add that on every rental, I do a PWC safety checklist. I do not allow any of my skis to be beached. I don't care if it's Fort Myers Beach, City of Sanibel Beach, if it's Cape Coral Yacht Club. They are not allowed to beach my skis for the simple reason that I don't trust anyone to turn off the jet propulsion engine before they bank the skis, which would allow sand and shells in them. Every ski is equipped with a sand docker with a 15-foot rope. They are instructed at thigh-high water to stop, sand dock the ski, and then disembark onto wherever they've stopped. My skis do not touch anyone's property.
All right, to wrap it up, sir, what time did you arrive here today?
I arrived here at about 10:15.
All right. Did you sign in when you got here?
I did.
Sign in list. Yeah. Yeah.
I don't have it.
Sir, I'm handing you a document, it's 2 pages. Would you identify it?
It's a hearing agenda sign-in sheet,
What number did you sign in?
Objection.
number 5.
Objection. What is the relevance?
There's no relevance on the sustained.
Actually, Judge, the relevance is the due process that my client's been denied, and I'll just make a record if Your Honor wants. Of course, you could deny me the opportunity to make a record, I guess.
If your point is that you were somehow skipped in the line, I mean, I believe you stated that
No,
early on.
Judge, my point
And you're having
is-
your full opportunity. In fact, you have had the longest hearing time, probably since I became magistrate in the town of Fort Myers, that I've given anybody.
It's one more piece of evidence that the prosecution is engaged in unethical and prosecutorial misconduct by hiding evidence and
Objection.
now blocking our access to the court.
Objection.
Also, it's sustained. You're having your opportunity to be heard. You've had plenty of time. Please proceed with the facts as it relates to the case.
And I have no more questions of this witness, Judge. One more page, I just want to make sure I go back. It was a Facebook post. Okay, you put it back, all right.
I'm here because it probably is going to be easier. Sir, does your company maintain a website?
Yes.
Does your company maintain a Facebook page?
Yes.
You have seen, have you not, the documents that that the town has entered into evidence? Facebook posts?
No. This doesn't show business on Fort Myers Beach.
He hasn't asked you a question yet.
Oh.
I'm not asking you, I'm just asking you.
Yes, I've seen them.
Recognize them.
I do.
How do you recognize them?
They're my posts.
Okay, all right. So you would agree with me that 3, 4, 5. You're holding 6 pages in your hand, or you have in front of you?
That would be correct.
And you recognize all of them, and it is your testimony that these are your posts or have been posted to your Facebook page?
Correct.
Does, on any of those pages, is there a reference to on-site water sports and what's commonly been referred to and known as the Roar Offshore event, the boat races?
There is.
Where did the boat races take place?
Offshore Fort Myers Beach.
Okay. Is there any other reference in the 6 pages that you have in front of you, either posted by you or presumptive customers of yours, as to Fort Myers Beach?
Ask that question again and be a little more straightforward with me.
Is there a reference to Fort Myers Beach on any of those pages, either posted by you, your company, or by customers of yours?
In the reference, Your Honor, of why we're here, no.
There isn't on page, the one that is on the top center, reference IMG 0465. See that one?
I do.
Is there a reference to Fort Myers Beach on there?
Not in the manner in which we're here.
That's not my question, sir.
That's my answer.
Is there reference to Fort Myers Beach?
Yes.
Okay, thank you. On the document that I'll refer to as IMG 0464, do you see that one?
I do.
Okay. Is that your post or that of a customer?
It's my post.
Does it state or reference Fort Myers Beach?
It's mentioned.
Does it in fact say, getting these jet skis ready for Three Island Hopper Tour tomorrow? Customers will ride through Fort Myers Beach, Sanibel, and St. James City?
Through, as in passing by, yes.
Okay. On the next one, I'm going to refer to IMG 0462. Do you have that in front of you?
I do.
Very mention of Fort Myers Beach on there.
In the way they do business, yes.
And you are presumptively soliciting customers on Fort Myers Beach?
Simply making the community aware of the different business practices that are available and business models in the jet ski rental community.
That includes Fort Myers Beach, correct?
That includes any jet ski rental company here in Lee County.
Which includes Fort Myers Beach, correct?
Absolutely.
Okay. I'm going to refer to you IMG 0466. Do you see that?
Yes.
Is that a posting that from you or your company?
It is.
And does it mention Fort Myers Beach?
It does.
Can you please read it?
So is this how you spend your money when you rent jet skis on Fort Myers Beach? When you rent with us at On-Site Water Sports, not only do we deliver, but you get free range riding. With a picture, you haven't let me finish because there's more.
Please.
With a picture of jet skis out in the water, it says, and they charge $100 to ride like this.
So one would assume that you're targeting the patrons and people who are in Fort Myers Beach, since the picture is of Fort Myers Beach? If not, you can answer no.
I object to relevance. I mean, it seems to be, it's a completely different allegation. Whether or not he's competing with businesses on Fort Myers Beach or trying to steal their business. Are we here for a intellectual property right issue?
I'm going to allow it. I know what you mean. I'm going to allow it.
Well, of course.
For limited purposes. Go ahead.
I cannot comment on what people's speculation would be.
Do you market to and do you try and obtain customers who are in Fort Myers Beach?
Yeah.
Okay. Do you maintain a website?
I do. I've answered that already.
Okay. If I showed you your website, would you recognize it?
I would.
Okay. And we will provide a printout of this and we'll enter it into the record unless there's an objection. Okay.
That is our website.
Sir, does your website, is that your website that's shown on the screen of the computer in front of you?
It is.
Okay. Does your website have on the bottom a link that is titled Routes for You to Explore?
You'd have to show me where that's a link. But did you get to that page by pressing that link?
Yes.
Can you do it for me now?
rephrase that. I'm showing you a screen on your web, is this your website?
It looks like my website, but you had the table turned. You said that you got there by a link that I'm not sure is a link.
Well, let me rephrase. Is this your, to the best of your knowledge, your website?
Yes.
Okay. Is there a discussion about your packages? Is there a portion on your website that says our packages?
Yes.
And below that, are there various entries of what you offer as far as packages?
There are.
Is there a package offered that states Fort Myers Beach, Bowditch Point Park?
No. What you're looking at is you're looking at a picture that is not illegal to use on my Facebook or on my website, and it's a simple informational piece about Bowditch Point Park. Nowhere does it state that I will take you there. Nowhere does it state that I will drop off a jet ski there. It simply says Bowditch Point Regional Park is 17 acres that is located at the northern tip of Estero Island, which was taken off the internet. Nowhere does it state that that's a drop-off point. Nowhere does it state that I do business there.
That's not my question. Is it?
I'm just clarifying.
And that's fine. Is it under the heading of our packages on your website?
It is.
Sir, have you ever led a guided tour?
Not finished.
Oh, I'm sorry. I thought that's when you were handing me the computers. Okay, I'm sorry. I apologize.
Sir, you do not have a PWVL, as that term has been used here today, issued by the town of Fort Myers Beach, do you? Yes or no?
Oh, no, I do not.
Do you advise your customers when they rent from you that that you do not have a PWVL issued by the town of Fort Myers Beach?
Sustained.
Do you advise your customers in any way, shape, or form as to where they may or may not go and where they may or may not anchor?
Yes.
Do you advise them that Fort Myers Beach, they cannot go into Fort Myers Beach?
Yes.
How do you do that?
I've already answered that.
Do you have, I don't recall, but.
Okay, no, I have no issue. Every customer, all right, is stated because they're taking out $10,000 machines. All right, every customer does a walk around with the ski, safety checklist, also the do's and the don'ts. I always ask the question, are you familiar with the waterways? I don't care what their answer is. I still tell them, stay within the channels. You do not beach my skis. All right, I will know if you do because I'll keep your deposit. People don't want to lose their money, so they're going to do what they're told to do. My skis are not allowed to be beached on any property, on any sand, not on Sanibel, not on the yacht club, not on the river, not on Fort Myers Beach. Each ski is equipped with a sand docker with a 15-foot rope. They are instructed that in knee-high water, they can disembark the vessel grab the sand docker, stick it into the sand by simply stepping onto it, and clip it to one of the eye holes on the front or the back of the ski.
I understood. Regarding that last issue, as opposed to, my question wasn't about pushing it up onto the beach. I'm simply, do you advise your customers where they can anchor and where they can't?
Yes.
Do you advise them they can't anchor in Fort Myers Beach?
No.
Nothing further. We will move into evidence the web pages.
Let me get the microphone. Sir, have you ever led a guided tour on jet skis?
Objection asked and answered.
No?
Nor part of my cross-examination.
I agree, sustained.
He asked about tours, Judge. I'm asking him if he ever led a specific kind of tour. He opened the door to that.
The packages, he asked about the packages.
Yeah.
Package is fine.
All right, do you take your customers on those packages?
No.
Okay. Is it your understanding, sir, you're here today because one of the allegations against you is the people who rented your jet skis went to Fort Myers Beach and spent money?
Assuming so.
Okay. Does Sanibel require you to have a license, sir?
Objection. The Sanibel's regulations are not at issue here.
All right. You said you do try to get customers from Fort Myers Beach.
I did.
Why would you do that?
I'm a business owner. I solicit business.
So if a customer decides not to rent at a Fort Myers Beach place and to rent from you, is it your understanding you violated the code?
No, it's all done on their own free will.
Okay. I have nothing further.
Question and only one question. Sir, did I just hear you say under oath that you solicit customers in Fort Myers Beach?
I asked and answered. That was your question. He asked the same question. You know,
Sustained, he did answer the question. He did.
Okay.
You have a follow-up on it? All right.
No, I've got one more.
Buy advertising in Fort Myers Beach?
no.
Do you buy any advertising from an advertiser like a newspaper or any of the airplane riders or anything that specifically advertise in Fort Myers Beach?
No.
Where do you get your advertising?
Google, Facebook, and periodicals?
Put up any signs on Fort Myers Beach?
No.
Put up any signs anywhere?
No.
So how are you targeting Fort Myers Beach customers?
Their assumption, sir.
Okay? When you put on the ad, hey, don't rent there, rent here, isn't that targeting Fort Myers Beach customers?
I believe so.
Anything wrong with that?
No, sir.
Been accused of anything here today because of that?
I've yet to see the evidence that accumulates to that.
Oh, wow, so that's really not relevant, is it? Nothing further.
I do have one question. Yes. Has your company or yourself delivered any of these jet skis within the jurisdiction of Fort Myers Beach?
No, ma'am.
No delivery whatsoever?
No, ma'am.
So in your Facebook postings where it says that they'll provide free delivery services, that does not qualify for delivering services in Fort Myers Beach?
I'm glad you asked that question. Allow us to clarify. So when we mention delivery, that means to the boat ramp, okay? My partner, Susha, right here, we're the only ones that operate the business. We have no employees. It's her and I. When I'm at work, at my regular job, she runs the operation. We run it together on the weekends. We cannot take jet skis and leave other jet skis unattended to go to a location to tow jet skis to another location because, one, when you tow jet skis that aren't being powered, you can flood out the jet propulsion engines. It's unhealthy for the machines. We meet the customers at the boat ramp. you guys have no boat ramp for me to utilize.
If you give us a minute, we are looking for a photograph that has been, that shows the jet skis behind the business here in Fort Myers. You know, we're
I-
you know what?
yeah.
It's.
I think at this point
Okay,
in time,
that's
we're
fine.
past it.
That's fine. Okay,
All right, so
nothing further.
do you maintain any of these jet skis in Fort Myers Beach?
No, ma'am.
One last, there was testimony. Yeah, I'm sorry.
Oh, we're done.
Yeah, okay. Nothing.
Hereby find that based on the evidence presented, that there is no evidence that these jet skis have been in the jurisdiction of Fort Myers Beach outside of a customer actually driving it on the outskirts of the water, which actually would be federally owned and not within the jurisdiction of the city of Fort Myers. However, I hope that this serves as a warning that should you engage in any business in the city of Fort Myers Beach or any of those jet skis actually making within jurisdiction, you are going to be fined, okay? All right, and since there is no finding, no evidence that would support the violation, there's no fines and no administrative fees. Okay.
Your Honor, at this time, we'd like to call case number I believe 29.
29.
Yeah, 29. And this would be, I mean, it's agenda number 29, case number CE 190077. The property owner is Kevin and Nancy Johnson.
Special Magistrate, you may recall that this case has already been heard, and there was a continuance to allow the...
Boathouse.
I'm sorry?
Boathouse.
The boathouse, that's correct. To allow the city to obtain some additional evidence that may support the allegations of violation. So we have the officer here present. Officer Lee, you've previously been sworn, is that correct?
Correct.
And you are employed by the town of Fort Myers Beach as a code enforcement officer, correct?
That's correct.
Are you familiar with this case?
Yes.
Okay. What has been your involvement in this matter?
Just following up with the previous code enforcement officer that was handling the case and inheriting and continuing the investigation.
Okay. And what was that investigation?
The dot setback encroachment.
Okay. And did you make any observations or measurements or any other type of site visit that
Yes.
would assist the special magistrate coming to a final determination regarding this case?
Yes.
Can you please tell her what that was?
Yes, me and another code enforcement officer took a boat to 126, 128, the channel, and measured the boat dock. If you see pictures that we have, we measured the length and the width of the boat dock, and also have other pictures from LIPA that shows from the property line to the riparian line, that's what's considered the navigable channel. and measuring that, and approximately it shows 83.68 feet. So if you divide that by 4, because of the ordinance says it can't be past 25% of navigable channel, divided by 4, you get 20.92 feet. So what that means is that the boathouse cannot exceed that amount. So if you see another picture from LIPA measuring the length of the width of the boathouse from the property line, it shows that it's approximately 25.01 feet, which exceeds the 25% navigable channel based off the calculation that we did.
And you say it's encroaching about 25 feet? 25 feet?
Yes.
Past the,
Past the 20.92 feet that it has to stay in below. So it stay under 20.92 feet. So it went to
how much?
5 feet.
We'll
Yeah.
keep it,
Yeah,
we'll
five-
keep it simple.
yeah. 5
How
feet,
much,
yeah.
what's the compliance? 5 feet, okay.
Yeah.
Okay.
Sorry, I made it complicated than what it needs to be.
That's okay.
So based upon staff's inspection and on-site measurements, this boathouse exceeds the size limitations in the town's code?
Correct.
Okay.
And I remember this was, we had a boathouse that was present. It was, when it was built originally, it was within the
county
jurisdiction of the county. Then Fort Myers Beach became incorporated and it took over. And that's after the fact, that's when the new setbacks were installed, but the boathouse would have been, the old boathouse would have been grandfathered in.
No, there actually was a permit that was obtained to install this particular boathouse after the town incorporated, and the issue is that a permit was issued by Lee County as the service provider for the town. The town had entered into an interlocal agreement with Lee County to provide building and zoning services for a period of time, and under that interlocal agreement, an application was submitted to the town, which was processed by Lee County, and a permit was issued.
With the 5 feet over.
With the 5 feet over. That is
Got it.
correct. Although the plans show otherwise. That, and you know, the applicant may, or the property owner disagree, but the dock wasn't built to code.
I'm gonna, let me know when I can switch over back to her,
Yeah,
because
by all means.
I'm trying to piece it together, because I vaguely remember it. Okay, go ahead.
We, at this point in time, we'd like to supplement the record, and I have to apologize. I don't know whether or not we got to the point of entering the file into the record before the matter got continued.
I don't remember, but you can,
But
move it.
we'll, unless there's an
Yeah.
objection, we'd move into evidence the file that shows the pictures, and we'll certainly provide them to the applicant, to the property owner if they wish, showing the subsequent site visit measurements.
Go ahead, because.
Yes, Kaylee Tuck for the record, with Henderson Franklin here for the property owners.
It was my recollection, right, that it was an old boathouse, and then there was a rebuild of it, but it was supposed to stay within the same footprint.
So I want to point out, the boathouse and the dock, I believe, should be separate. They have separate code provisions, and our notice of violation specifically reference the dock setback issue. So I want to parse those arguments out. The boathouse has already been cited for a setback issue, and that was a code enforcement case back in 2018 that was decided there was no violation.
That is correct. So
So it's only the dock.
It's the dock, and the photographs show are measurements of the dock. The if the special magistrate and Ms. Tuck, I'm referring to this particular photograph, of one of our code enforcement officers holding up the tape measure, the boathouse component is to his right in this photograph, and what was being measured was the dock. And that's the issue before the special magistrate.
So the dock is what is actually exceeding the amount, not the boathouse?
That's correct.
But as we argued last time, as we still maintain, the dock is a non-conforming use. It was built in 1975 and has not been altered in terms of the footprint.
The town's position is, Frank, it's the legal argument. We're not necessarily disagreeing. We don't have, I think, a disagreement on the facts. It's the question of, was the permit that authorized the dock to be built compliant with the code? And the evidence we allege that has been submitted shows that it was not, and therefore the property owner doesn't have a right to rely upon that permit because it was issued under a mistake of fact.
Mr. Aaron, do you mean the original permit or the 2013?
The 2013.
Okay. Well, in terms of that, it said that the dock was being rebuilt in the same footprint, which is allowed under the code. I believe Mr. Heron is referring to the boathouse amortization provision, which specifically does not apply to docks.
And we agree. That was part of the discussion that took place at the last month, at the prior
Regarding
hearing.
about his, but normally when we have a building code, sometimes it does happen that permits are going to be issued contrary to what the code requires, and obviously the code is going to control. And then it goes into the distinction whether, because it's an older dock, whether it was something that could be grandfathered in, but the grandfathering ends the minute you touch it. The minute you go ahead and make changes to it or you make repairs to it, now you fall within the new code requirements. Am I?
Section 26-48, non-conforming marine structures, it says except where prohibited for boathouses of this chapter and for seawalls of this chapter, a non-conforming marine structure may be repaired, replaced, or altered if, and then it basically states that if the non-conforming status is not expanded.
But I thought we retired the fact that we're not here for the boathouse, we're just here for the dock.
Right, it specifically eliminates boathouses from this provision and applies to docks alone. I can bring you one.
If you could, please, because I'm trying to see if I have it, and at least the way that I heard you say it, it sounded boathouse related, but not dock related. So I heard it backwards then. Oh yeah, I do have it. Yeah, I think it's. Oh, no, that's not what I have. In that section that you're giving to me is, it says that it will otherwise remain in compliance with all existing regulations. It seems to me that what the town is saying, and I'm still trying to piece the facts together, that when the repairs to the dock were made, that the regulations had changed. And before you respond to that, go to the mic. Thank you.
Well, it seems to me that this is allowing a non-conforming use to keep their non-conforming status as long as they are not expanding the non-conforming use, which in this case we were not.
I think the key word is in the last portion of that sentence where it says that unless it otherwise conflicts with existing regulation.
Right, but I think in terms of the purpose behind this provision, is trying to keep the non-conforming status just in the same footprint. I understand the argument, but
I'm really bending over backwards because obviously sometimes there's a distinction between you fixing one plank versus you doing a replacement of all the planks, which would be more extensive. Even with like building code, you can have something that's grandfathered in completely out of compliance the minute you touch it. Now it falls within the code, and it has to be adapted to that code. So it sounds to me like that is the scenario you have here.
well, in terms of the actual permit itself, you know, it's marked as a re-roof in the e-tracket system. So it wasn't necessarily a rebuild. It was just moving the planks around, so to speak.
It seems like once you touched it, it had to come into compliance. How is shortening the dock a viable option?
I think if
And
we
I'm
want to
speaking
go
out loud more than anything else. Is it?
I think if we want to go that route, we obtained a survey showing that we are not encroaching on the 25% setback.
That obviously is an issue of fact for the special magistrate to
I know.
determine.
I'm trying to do two things because I think the violation's there. I really do, for the reasons I just said. But at the same time, I'm trying to go ahead and find what are the alternatives that the homeowner has, because that is also going to influence how much time and fans and all that other stuff. So
The town respectfully suggests to the property owner that the non-conforming marine structure provision that is being relied upon does say that it has to be in compliance with all existing regulations.
that's exactly what I said before.
You know, so it would have had to have been shortened, and why or how it got to encroach those 5 feet. Apparently, no one's no longer around, but it should not have been built that way under the code.
Well, originally they were fine because it passed. It was when they touched it to, I guess, update it, for lack of a better word. That's when the problem started.
I guess my point there is the very nature of a non-conforming use is the fact that it doesn't conform to the current regulations. So why put a provision that allows you to replace it if it has to be brought up to code?
Because the idea is that a nonconformity doesn't stay forever.
It has to be addressed somehow.
On that respect, may I submit the survey and evidence that we received?
Yeah, sure, of course, if you have it, yes. And I'm still having, like, the length that is at issue is the one that runs along the seawall. That's the dock that's at issue, correct? Or is the one that goes? The other one. I'm very visual, so I'm trying to go ahead and get myself, maybe that will help me. Okay, let's see. Okay, it's the walkway one.
With respect to the survey issue, and certainly survey is what it is, but I don't want to, staff can testify to this, but I'll lay the predicate is that because of the uncertainty of canals and how they get modified or can change over the years, particularly one such as this that's not the far side. It's actually mangroves that are bearing into the navigable area. Is staff uses the plat for purposes of measuring the width of the canals. And that's where the material that's been provided in the record will show that measurement.
It's not exactly the most actualized,
No, but that's,
measurement.
you know, the problem with relying upon a survey is that a survey is, you know, unfortunately subject to the vagaries of one, the surveyor and how he or she may determine the present line of the opposite canal, particularly one like this, which is, you know, doesn't have a seawall or other demarcation of consistent with the plat.
I understand the concern. I mean, you have, it's a mangrove you're measuring from, and that mangrove can change. After a hurricane, it's going to be very small, and under good conditions, it's going to be very big. If it's 5 feet, and the dock is the one that actually goes out to the boathouse. So even if the dock was shortened, just for the sake of argument, the 5 feet, the boathouse is still in the same place, so it still would encroach in the same amount of space, though, right?
Yes.
For practicality purposes, you can make the homeowner shorten the dock, but the boathouse has already been done and over, and that takes even.
We have been working with this property owner and their representative for some time to try and come up with a reasonable solution, and that those efforts have not come to fruition, unfortunately.
What has been the proposed solutions?
We had proposed to essentially amortize the dock and require compliance after passage. So essentially what we had fixed as the obsolescence of this encroachment.
All I'm having here is for practical purposes, shortening that dock those 5 feet is going to have no impact whatsoever because you have the boathouse there. So even though, and I understand, it's like, then you have the issue that it was that way before. Was that dock when the boathouse was originally built? Was that dock there and just as long?
Yes, the dock was built in 1975.
And the length of that dock in 1975 was the same as it is today?
Yes, and we have aerials of that if you'd like to see it.
If you could, please.
I don't mean to presume to speak for the property owner, but I think that we have agreed that for purposes of today, the issue is, does this qualify under the non-conforming provisions of the town code and general Florida law? You know, our argument again is that I don't have any objection. That you know, when they came into the new permit, that they are required to bring it into compliance. It's obviously an issue for the special magistrate to determine factually whether or not that's the case or not.
Okay, is there anything further that either party would like to add?
Special Magistrate, to the extent it affects your decision, the dock permit that we're referring to also changed the boathouse, and the boathouse was still found to be a non-conforming use in that prior code enforcement case.
I'm gonna do a little something, my order's gonna be a little unconventional, but still within the powers that I have and still within the powers of the statute authorizing my job here today. I hereby find that the violation as stated in the notice of violation did exist and continues to exist. However, I'm not going to impose any fines, but I am going to order the property owner if this dock or the boathouse is in any way, shape, or form repaired, altered, or any work is done, that the property will have to become into compliance. Basically, what I'm trying to do is that the compliance date for it to come in to correct the violation is going to be whenever that dock necessitates alteration, restoration, or repair.
That include immaterial repair, such as just replacing a board or something like that?
I think that would trigger under with the equivalent of the building codes. The minute you touch to repair, yes, it's going to trigger. And you're going to require a permit to do so, and at that point in time, you are going to be required to bring it into compliance pursuant to whatever code ordinance is regarding the size and setbacks of that dock. So just because there's one way now, they could be different when that time comes. So you're going to have to, your owner's going to have to comply with whatever is existing at that time. I think I'm going to have to, council's going to have to work a little bit on that order, or I can write it up. But the intent is for your owner to go ahead and, there's a violation, but there's going to be no fines, and he must come into compliance the minute that thing the dock has to be repaired, altered, or anything, then it has to be brought into compliance. Okay? Is the town clear with that? Yes. Okay. All right. Thank you.
Okay, Your Honor.
Here's your.
We're going to move to number 10, David Suda. This is going to be case number CE 190002, weekly rentals in a monthly zone. This is going to be presented by Kristen Schumacher, who is our short-term rental coordinator.
Ms. Schumacher, you've previously been sworn in, is that correct?
Yes.
And you previously identified yourself as a employee of the town of Fort Myers Beach who is responsible in part for the administration of the short-term rental regulations of the town. Is that correct?
Yes.
Are you familiar with case CE 190002, Amanda and David Suda, the owners of record?
Yes.
How are you so familiar?
I did the research, online research on the case. Sent officers to drive by to take pictures of different vehicles in the driveway.
Okay. And what is the violation that's being alleged?
Weekly rentals in a monthly zone.
Can you explain a little bit about that there's areas of the, correct me if I'm wrong, of the town that weekly rentals are allowed and other areas where they are not?
There's different zoning in the town. For example, 126 Coconut is considered a monthly zone. It's zoned RS, and they're allowed a minimum of 1 week stay to one family per month.
So it's, Special Magistrate, it's not that they have to rent for a month or more, it's that they can only have one rental per month. Whereas in other districts of the town, you can have more than one per month.
The rental itself doesn't have to be for the full month.
That's correct.
Okay.
But it is limited to one per month.
That's correct.
Okay. And you stated earlier that you did some research regarding this particular piece of property. Can you tell the Special Magistrate what that research was?
online and looked at their advertisements. They post rental calendars online. I have found I have to find, it's in this packet. There's availability, the kind of marked out looking ones in your packet. It shows how many times.
The only one I'm missing. I go to 12, 11.
What number are we?
10, it's number 10.
That's number 10.
Sorry.
It's okay. I was following you until you got into a look in the packet. Okay. Thank you, Daphne.
Well, basically, this started off as a complaint. This is the fourth case we had opened. Previous cases have been closed while they haven't found evidence, but there were numerous communications with the homeowner per email. So I did the rental calendar, and I came up with ones like you can see in March. There's 3 separate rentals for that month.
And so help me with this calendar. If the numbers are blanked out, that means it's rented?
Numbers are lighter or blanked out with a strike through, that means it's rented. If they're clear and you can see the number very clearly, that means it's available.
Ms. Schumacher, did you, this information that you're testifying to, where did you obtain it? On the internet?
Yeah, on the internet. We use a program, Host Compliance, which directs me to websites that each property is advertised on. One of the rental calendars is from flipkey.com. Flipkey, and this one I used Flipkey for all the rental calendars.
And based upon the information that you had available to you, you said that you sent a code enforcement officer out there to do an on-site inspection?
Yeah, I have Bill Stout driving by. Every day he is here, he drives by the houses and takes pictures and to show separate vehicles parked in the driveway each week or each month.
That match up with the calendar that you testified about earlier? Okay. Do those photographs show different cars?
They do show different cars right now with it not being in season. There haven't been
Ms.
any
Schmecker,
rentals. Oh,
The question is, on the dates that are showed as rentals, are there photographs showing different cars?
yes.
Okay. Was a notice, was a notice of hearing issued to the property owner?
Yes.
Was a green card or return receipt received indicating that the property owner received a copy of the notice of violation and notice of hearing for today's hearing? The green card, was there did staff
I have the
receive it?
certified receipt.
Okay, and so someone signed, you received back the green card?
Got proof of service of the
We
certified
didn't get a
mail.
green card back, it was unclaimed.
Okay.
We certified the letter.
Did you post the property?
Yes.
Okay. You posted the property after the green card was unclaimed?
We posted the same day we sent it out.
So you just, as a matter of course, you routinely notice or post the property in addition to sending out the notice of hearing certified return receipt?
Yes.
Okay. Nothing further, Special Magistrate, at this time. We'd like to move into evidence the file and the photographs, as well as the notice of violation, the notice of hearing, the posting, the printouts of the website that Ms. Schumacher testified about, indicating the dates in which the property was up for rental, the photograph showing multiple different cars during the same time frames.
Admitted.
Nothing further.
Okay. Please state your name and relationship to the case, please.
My name is Douglas Shaw. I'm here as a friend for David and Amanda because they couldn't get away. The time period whenever this happened, I've got some of the information, but back when this, in March, she was having severe brain issues. She ended up in brain surgery just a couple months later, so they were really focused on trying to keep her alive. So from that part, it's kind of hard to focus on a lot of other things that you're having to accomplish. So that's why whenever some of these rentals were taking place, they were family and friends coming as well. And then also my vehicle would be in the driveway, or probably even my wife's vehicle in the driveway at some of these times, because they had asked us to come over and look at the property, see if anything was broken, missing, because the people that were supposed to be taking care of it were not. So as for making sure that they were accepting monies for the rentals, I do not know, because I don't have privy to that information. I didn't talk to David much about that. And the information for him to try to get here on time, he said it was 6 days for him to drop what he was doing for his schedule, him and his wife's schedule, and he said they just could not get away, and asked me if I would come over at 8 o'clock this morning. I'm like, yeah, I'll come over and see what's going on. And I apologize for them not being able to get here. I know that's not orthodox, but for them not being able to rent it for many, many months. And I believe that they have come in compliance from what he said, but I don't know how to check any of that. So
Were they renting weekly? And
they were, and didn't realize it was to be an issue, and once they found out it was, then they changed that. And I believe if the clerk lady has that information on the turnkey or whatever the home site is, that as soon as they found out that it was an issue, that they did change it because of all of what they were going through, and that's why they just stopped having people come over. And I apologize for not having all the information, really.
I may ask one question. Sir, what kind of car do you drive?
I've got a 2011 red Mustang. I have an 04 F-150.
The one that you park in the property from time to time, which of the vehicles is it?
All those and the Jeep that
Okay.
we come over.
And Magistrate, the photographs that you have show no Jeep, show no truck, and show no, what was the?
Camaro.
Camaro. Mustang. Didn't you
No,
say Mustang?
Camaro.
the Mustang, yeah.
How dare you?
Camaro.
I was going to say, hey, I'm okay with that, but.
I'm just kidding, yeah.
I'm not seeing the notice of, oh, it's the one of those notice in violation and notices, both in one, sorry.
I believe he sent a letter in also a few weeks ago, I believe, trying to explain a little bit about it, and then once he noticed it was in compliance, because he emailed me the letter. I've got it on my phone if I need to have you guys look at it.
How long have they owned the property, do you know?
I believe 5 years.
Has it always been a rental?
Yes, it was supposed to be a personal place for them to come live at, but then they couldn't retire, so then they turned it into a rental at that point.
That's when they started renting it on a weekly basis?
But they were trying not to rent it at all, because they just loved coming over here. So you know how that part goes. They rent it during season, and they can't spend the time here from the other coast.
Town will offer that the property is, at this time, properly registered, but there still was unpermitted rentals taking place during the timeframes testified to, and asked that the special magistrate find the property in violation to the extent that the special magistrate is maybe so inclined as to maybe assess a flat fine, and so we can treat it as a repeat violation in the future and impose higher penalties. But the town would suggest maybe a $2,000 fine.
During the time where she had her brain surgery too, remember? It's, and I'm not trying to
I'm taking it
vacate
again.
that.
I'll take that into advisement. That's the city's request. Is the town requesting also administrative fee?
Yes, please. The amount of $150.
If I find that the violation as stated in the notice of violation did exist, however, that the property owner has come into compliance, I'm going to impose a one-time fine of $250 and fees and costs as incurred by the city in the amount of $75, all which shall be payable within, you want to do 10 days? Obviously, if they do it again, it's going to be a repeat, and it goes up to $500 per violation. So I went very lax on it.
Don't blame you. I do appreciate it. Thank you very much for your
Let's
time.
make sure that it doesn't happen again.
Yes, ma'am.
All right. Next case.
Okay, Your Honor, we're going to number 11. This is going to be David and Mardina Andrews. This is case number 190072. This is also weekly rentals in a monthly zone. Presenting the case is going to be Kristen Schumacher, our short-term rental coordinator.
Special Magistrate, make a suggestion to the property owner that you know, the nature of the violation is the same as the previous case, and the testimony is going to be essentially the same, and presumptively, the determination of the Special Magistrate would be similar to what was just ordered. My question is, would the property owner agree to the entry and order violation on the same terms and conditions as the previous one, at $250 fine?
If the property owner wants to stipulate to that without hearing any evidence, the parties are free to go ahead and do that.
Yes.
Okay.
But I was so excited to speak. I love law and order.
It's you know, in an attempt to save everyone time, if we can stipulate that we'll enter the file into evidence that there is a violation, and consistent with the Special Magistrate's previous order, a fine of $250 a day plus $175 administrative fee payable within 10 days.
Respondent on behalf of the property owner. First of all, please state your name and relationship to the case.
My name is Tracy Palin, and I work for Turnkey Vacation Rentals. We manage the property.
And you're authorized to speak on behalf of the respondents?
Yes, I am.
Is the respondents stipulate to what has been presented by counsel?
What is that stipulation?
Do you
I'm sorry.
agree? Do you agree with the proposal by counsel?
Yeah, I agree.
Okay, based on the agreement between the parties, I hereby find that the violation as stated in the notice of violation did exist. I'm imposing a one-time fine of $250 and assessment of fees and costs in the amount of $75. We shall be paying, all we shall be payable within 10 days, and with a reminder that they're now going to be a repeat violator if they do it again.
You like the proof that we are in compliance? Do you need that?
Yep, and the record reflects
There's
that they're
okay,
in,
so
they are in compliance, but were not in compliance during the time frame specified.
And as part of my order, I'm hereby including the fact that the property is in compliance.
Thank you.
But any future violations will be at the rate of $500 per violation.
Understood.
Your Honor, next, number 12, Wilfredo Rodriguez, case number CE 19-0110. Presenting the case, Kristen Schumacher, short-term rental coordinator.
Again, Special Magistrate, if subject to the property owner's representative agreeing, we would suggest the same solution or proposal to this case, since the facts and evidence are essentially going to be the same, and given your prior ruling, we suggest entry of an order violation and imposition of $250 fine and $75 admin fee payable within 10 days.
Or if the parties want to go ahead and enter that agreement, I'm perfectly fine with that, and I'll issue a ruling accordingly. Is that, could you please state your name and relationship to the case, please?
Rodriguez, owner.
Okay.
And yeah, that's fine.
Based on the agreement by the parties, in regards to this case, I hereby find that the violation as stated in the notice of violation did exist. I am imposing a one-time fine of $250 and assessing fees and costs in the amount of $75, all of which shall be payable within 10 days. And is there a finding also property is in compliance?
No,
Oh,
Oh, sorry.
I do not see any compliance.
Okay. Take that back.
Actually, it was updated. I updated it online a couple days ago. And it's also,
Sorry, need to move
and it's
on.
also,
Let's check, we'll check real quick.
and it's
Bear,
also
give her,
registered.
give her 2 seconds to go
Sure.
ahead and check to
Okay.
make sure that they got verification, and if not, you put them on notice. And let's go ahead and, as I call the next case, but apparently not.
Spoke too quick.
Yes, you did.
Well, the evidence that we were going to present actually shows that he has rentals scheduled for December.
Is that the case you have for December?
I'm not sure what I have scheduled already, what they've accepted, but I did update the online website so that from now on, it could only rent in 30-month increments.
Okay, so what I'm gonna do is I'm gonna go forward with that order with the exception that I'm giving you 30 days to come into compliance. That's gonna,
And I'm
What
sorry,
you-
what would compliance mean?
that you can't do it anymore.
Okay.
That's it,
like-
because that way you can go ahead and finish off the ones that you have, because I understand the logistics of it. So I'm gonna give you till December 31st. Otherwise, face a fine of 250, actually, no, at that point in time. The first time, right, for him?
Yep, the,
Okay, so what I'm gonna do is I'm gonna, as to this one case, for him to cease, to come into compliance within December 31st, and then $250 per violation
Okay.
thereafter. Okay, so you have until December 31st of 2019 to go ahead and complete the reservations that you already have, but by January 1st of 2020, that's it. That's, if they catch you with violating the code again, the ordinance, you're gonna be fined $250 per violation.
thank you.
All right, thank you.
He is next as well.
Oh,
He owns 2 different properties that have violations, and he's number 13. The case number is CE 190520. It's the same violation, although this is rentals for less than 1 week. So he is in a weekly rental zone, but he is renting daily. It's the same kind of violation, but different.
okay.
There is no limitation on the number that he can have in a given month. They just have to be no less than weekly. Does that make?
But it's not daily. I mean, it's like.
I thought it was backwards daily.
Minimum of 1 week stay.
It is a minimum of 1 week
Minimum
stay.
1 week stay, okay.
Yes.
So he could have 4 rentals, but they can't be less than 7 days. Yeah.
Can you obtain that information? You want to go ahead and have her?
Or it's not in compliance. It falls in the same fact patterns as the previous one, and ask that the special magistrate enter a similar order in case I'm sorry, CE 190520, if that's acceptable to the property owner.
It is? Okay, so we have an agreement on there until December 31st. So I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby imposing a one-time fine of $250 and ordering the property owner to come into compliance by December 31st of 2019. Otherwise, face a fine of $250 per day for each
Occurrence.
per occurrence.
$75 admin.
Plus the $75 in fees and costs as incurred by the town in bringing this matter before the magistrate. Okay.
Next on the agenda is number 14. The property owner is Dockbone Properties. The case number is CE 190518. This is rentals for less than 1 week. So he is able to rent for a minimum of 1 week, in 1 week increments, not less than 1 week. And Kristen Schumacher, our short-term rental coordinator, is presenting the case.
Again, in order to, potentially save the property owner as well as the special magistrate in town, the time we'd suggest the same order be entered in this case as was just entered in the previous case.
Is the property in compliance?
No.
What is the property owner's, could you please state your name in relation to the property?
Yeah,
Please?
David Helligman. I'm the owner of the house.
Okay. Also, for the town is presenting an offer.
Yes.
Do you accept it?
Yes.
In regards to the
I'm
agreement?
just not sure where I'm not in compliance now.
Okay, that's what I was going to say. I was going to ask, does the property owner understand the nature of the violation he's being accused of violating? Is that you cannot have rentals at your property for less than an entire week. Okay.
I've been renting this house for 15 years, and I was under the understanding that it was weekly rental, and there was 1 rental per week. I don't even know if the rules changed like a year ago, because I think you changed.
No, it's always been that way. So as Ms. Schumacher testified, it's a maximum of 52 in a year that he could conceivably have at this particular piece of property, no rental less than 7 days.
Based on the parties' agreement, I hereby find that the violation as stated and the notice of violation did exist and continues to exist. I'm ordering the property owner to come into compliance by December 31st, 2019. I'm imposing a one-time fine of $250 and assessing fees and costs amount of $75 as incurred by the city. In bringing this matter before the magistrate, those amounts are due and payable to the town within 10 days.
Yeah, 30 days to bring into compliance any of the
Yeah,
outstanding.
I'm giving them till December 31st to get past the December season, the Christmas season. So.
Okay, next, Your Honor, is number 19. This is Bessie James C. Oh, I'm sorry.
15?
Oh, wait a minute. 15?
I had circled that someone was here for 15.
Oh, no, all of those, the 15, I'm sorry, 15, 16, 17, and 18 have been continued? Okay.
Okay.
We're here in case
Okay.
19, right?
Yeah, we're at case 19. Again, this is James Bessie, case number CE 180902. The code officer presenting the case is Eli Lee. This is a repeat work without permit, the tiki structure.
Officer Lee, you've been previously sworn in, is that correct?
Correct.
And you've also testified that you are an employee of the town of Fort Myers Beach?
That's correct.
And your responsibilities are as a code enforcement officer?
Correct.
Are you familiar with this case, CE 180902?
Yes, it's a case I inherited from the previous code enforcement officers, but I did research the case, so yes.
You've reviewed the file?
Yes, I have.
Okay. Can you please advise the special magistrate what the file discloses and your involvement in the case shows?
Yeah, sorry. This is a work without permit repeat for a tiki hut. As you see, of course, you need a permit to build a tiki hut in town of Fort Myers Beach. There was no permit on file for the building of a tiki hut. If you go through the folder and you see pictures from VRBO, you see the tiki hut still present. Also, I took pictures of the tiki hut from outside the house. If you look behind the car porch or the garage, you see the tiki hut still present. And the next photo is a more zoomed in photo. You see the tiki hut still present. And our records also indicate that there still has not been any permits filed with the town of Fort Myers Beach for the tiki hut.
Did you send out was a notice of hearing sent out?
That's correct. Yes.
Was the property posted?
Correct, yes.
Did you receive back any, the mailed notice?
I don't have it with me, but I don't believe I have.
Okay, so, but it was posted?
It was posted, yes.
Okay. And the property still is not in compliance as of this date?
As it is, still not in compliance.
At this time, we'd enter into evidence the file showing the notice of violation, the notice of hearing, the posting, and the photographs showing the violation,
Admitted into evidence.
as well as a copy of the town's permitting file showing no permit.
Hi, I'm Laura Bessie. I'm one of the owners of the property. The tiki hut was built about 3 years ago by the Seminole Indians, and I have had going back and forth about the information as far as whether the structure was allowed to be built without a permit, and this has been going on for a couple of years. However, yesterday, I did have a surveyor come in 6 months ago when I got the notice of violation, and he did a survey. I noticed that on the survey that one of the posts of the tiki hut was 6 inches too close to a setback. I had to contact the tiki hut builder to come and move it out of the setback so that it was within the parameters of the town. And so they did that. However, it took them months to do it. They only just did it like 3 weeks ago. And I called a surveyor to go back. He did go back. I got the engineering structuring files and everything was submitted on Monday. However, it was rejected because the permitter, the Tiki Hut Big Kahuna permitter, filled out the wrong permit form, but she didn't know about it until yesterday. So she filled out the new one and then resubmitted the engineering, you know what I'm talking about, the structurals, and the Seminole Indian letter, and all that other great fun stuff. And I'm not a lawyer, so.
So you are in the process of getting the permit. You've applied for it.
It has been applied. It was electronically submitted yesterday. I did get confirmation by the town that they did receive it yesterday afternoon. So I apologize. We didn't know about it being kicked back on Monday by filling out the wrong application.
But you now know that even though it was done by the Seminole tribe, that it does require a permit, correct?
Yes, but I do have documentation from someone in the town that I didn't need it.
Yes,
So
it's a common misconception.
Absolutely,
And it's not
but
only
that's-
isolated here, like everywhere.
even though they said that, I still went ahead and wanted to get this done. Unfortunately, it did take me so long, and I apologize, but I got it done. And if you still tell me to take it down, I do need an inspection though.
Well, in this one is just, once you obtain the permit, you're in compliance. The challenge is going to be getting the permit.
Okay. So it was.
All right.
We, based upon the evidence testimony, we recommend that the special magistrate find that the property is in violation, give the property owner 30 days to obtain the permit.
Literally what I have written down here.
And if not,
Thank you.
Leaving the special magistrate's discretion as to what the appropriate fine would be and ask the imposition of the $75 admin fee.
Thank you.
I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm imposing a one-time fine of $50 and ordering the property owner to come into compliance within 30 days, otherwise face a fine of 150 days per day until the violation is corrected. I'm also assessing $75 in fees and costs as incurred by the city in bringing this matter before the magistrate. So you got
You said 150 days. I think you meant $150.
Yes, I got
150.
that. $150.
Sorry.
It's been a long day.
It's been a long day.
You've had a rough day. And I don't want your job
$150.
over there. I don't want a code enforcement job.
So yeah, $150 if you don't come into compliance. However, if you encounter any issues, stay in touch with the code enforcement. Let them know what's going on. That's super important.
All right, I'm going to
Okay.
chase him down right now. Thank you.
All right, good luck.
Thanks.
Right, Special Magistrate, I believe that's all the cases we have where there are people here to testify, unless.
Do we have people out there also? I think
You know,
that
yeah,
I think there's another
yeah,
gentleman.
I think they may be working through that. I'm sorry. As she runs it.
Okay, luckily, Your Honor, we're at the place where we have no more, although we
Okay.
have more on the agenda.
Perfect.
So
All right, so
we
let's go.
can hopefully, the next one, okay, you can see 20 was continued, 21 is compliant, 22 has been continued, so we are now up to number 23, Eli. Where's Eli? Which is going to be Gales, Maryland. This is going to be a work without permit. This is an expired, I'm sorry. What?
8 and 9.
Hold on, let me see. 5, 6. Oh, that's true. We'll go back to 8. I'm sorry.
Yeah, well, I don't have 8 and 9. I literally did my count, and I guess it's the same place where the number 10 was.
You don't have that on your agenda?
I have them on the agenda, I just don't have folders
have
for
the
it.
Oh my. Okay.
We can just go ahead and do the back end and then go back to that
Here's
9
8
and
and
10.
9. Here you go. You can just have mine. I don't. Our code officer.
Yep,
Yeah.
can't do much without him. Welcome back.
8 on the agenda. Oh, Officer Lee, you've been sworn in, correct? Correct. And you are a code enforcement officer of town of Fort Myers Beach?
That's correct.
All right. Are you familiar with case 2019-0636?
Yes, I'm familiar with the case.
The property is 2924 Estero Boulevard, Unit 301.
That's correct.
The owner of record, Jack and Michael Porter, or Jackie, I'm sorry.
Yes, that's correct.
Have you reviewed the file?
I reviewed it, yes.
Can you please tell the special magistrate if you're familiar with this property and how you are so familiar?
I'm familiar with the property based off investigation that we conducted. As of right now, the property is not in compliance because they have not registered short-term rental.
So there are a series of what appear to be computer printouts in the file. What are those?
Calendars and reviews and notice of violations that have been sent out.
Okay. And under the code, are any short-term rentals in the town required to register?
Correct, yes.
Is this one registered?
It is not.
Okay. Was a notice of violation, a notice of hearing sent out to the property owner?
Yes.
Or was the property posted?
Yes.
Okay. Property as of today's date still non-compliance and unregistered as short-term rental?
Yes, it's still not in compliance.
Madam Special Magistrate, that concludes the city's presentation. We move at this time the file into evidence.
File is admitted into evidence. It is hereby noted that we do not have anybody present on behalf of the property owners. What is the town requesting?
Yeah. The ordinance for short-term rentals specifies a fine of $500 for each day that the short-term rental is unregistered under the town's regulations. We'd ask that the special magistrate enter an order requiring the property owner to come into compliance within 50 days, because this is a fairly easy process. It's online to register the short-term rental. If they don't come into compliance within that time frame, that the fine specified in the code be assessed for each day thereafter.
I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I hereby impose a fine of $250 and order the property owner to come into compliance within 10 days. Otherwise, face a fine of $250 per day until it's brought into compliance.
$75 admin fee.
And I'm also assessing the $75 in fees and costs incurred by the town in bringing this matter before the magistrate.
Thank you.
And since this is a failure to go ahead and register and they're posting online, the per diem.
Correct.
is
So
the proper.
the next case, number 9 on the docket, and code case 2019-0637, is the same property and property owner. The violation is similar, related to the short-term rental. Not only are they not registered, but they have failed to, because they failed to register, they don't have the required registration number on their advertisement. Again, Officer Lee is here to testify to the facts. I'm sorry. Officer Lee, you've been sworn, correct?
Correct.
And you are a code enforcement officer of the city or the town of Fort Myers Beach?
That's correct.
Are you familiar with this case?
Yes.
Can you please tell the special magistrate how you are so familiar?
This case has been brought to investigation, sorry, in regards to the registration not present on all forms of advertising. As of today, the registration number is still not present on any of the advertising for the property.
Does the file that you reviewed show any printouts from any web pages regarding the ongoing rental use?
Yes, we have screenshots from multiple third-party websites for short-term rentals, and on the third-party website doesn't show the short-term rental registration number on the property, as well as any calendars or reviews, or even the property itself still doesn't have the short-term rental registration number on them.
Was a notice of violation, a notice of hearing sent to the property owner?
Yes.
Was a notice of violation, notice of hearing posted on the property?
Yes.
Has the property owner responded in any way to any of the attempted communications by town staff?
Not that I'm aware of.
Okay. As of today's date, does the property still fail to have the registration number on their website and their advertisements as required by the town code?
Yes.
Mr. Magistrate, this time we move the file into the record showing the aforementioned violation photographs, screenshots, evidence of the posting, as well as the mailing of the notice of violation and notice of hearing, and request that the special magistrate find the property and the property owners in violation of the code and assess the same penalty as the previous case that is related to this one, fine of $250 plus $75 admin fee, 10 days to comply, or $250 a day thereafter.
Town's case file is hereby admitted into evidence. It is hereby noted that the property owner or nobody on his or her behalf are present today, I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm imposing a one-time fine of $250 and ordering the property owner to come into compliance within 11 days, giving him 24 hours to get the number and put it in the advertisements. 11 days. Otherwise, face a fine of $250 per day until the violation is corrected.
Okay, we're on to number 23 now. The property owner is Maryland Gales Trust. The case number CE 190548, work without permit, expired fence permit. The officer presenting the case is Eli Lee.
Officer Lee, you previously been sworn, correct?
Correct.
And you are an employee of the town of Fort Myers Beach in the capacity as code enforcement officer, is that correct?
Yes, that's correct.
Are you familiar with case number CE 190548, the owner of record trust for Maryland A. Gales Trust?
Yes.
Can you please tell the special magistrate how you are so familiar with this case?
Yes. Investigation determined that the fence permit that they have has expired, and there has not been any remedy for getting a new permit to, renew the fence permit or getting the property back into compliance. So there's pictures of the fence, how it's still present on the property, and as of to this day, there is still no permit that has been applied for to fix the situation.
Did you have any, did you attempt to contact the property owner?
Yes, through sending out combos and things of that nature. But
Did anyone communicate back with you?
no.
All right. Did you send out a notice of hearing, a notice of violation to the property owner and post the property?
Yes.
As of this date, has any attempts been made by the property owner to either renew the permit and obtain a final inspection for the fence in question been obtained?
No, not to my knowledge.
Special Magistrate, based upon the evidence testimony in KCE 190548, we'd ask that the Special Magistrate find the property owner to be in violation of the section of the code cited by town staff, give the property owner 30 days to obtain, and I understand your hesitation, Special Magistrate, but the issue here is not just obtaining or renewing the permits, getting it closed out, which requires final inspection. Because just obtaining the permit is where we're theoretically where we're at right now.
I understand that. Unfortunately, the violation, the way that the notice is written, is just the requirement of the permit.
If they do not come into compliance within the time frame that specified by the Special Magistrate, that we ask that a fine of $175 a day be imposed, and we also ask that the Special Magistrate assess the $75 admin fee.
I noted that nobody is here on behalf of the property owners. I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby ordering the property owner to come into compliance within 30 days. Otherwise, face a fine of $150 per day until the violation is corrected. I'm also imposing assessing fees and costs in the amount of $75 as incurred by the town in bringing this matter before the magistrate.
Next item on the agenda is the same property owner. It's a different permit, so that's why it was cited separately. Case CE 190549. Officer Lee testifying. Officer Lee, have you previously been sworn in?
Yes.
Are you employed by the town of Fort Myers Beach as a code enforcement officer?
Yes.
Are you familiar with the property at 3180, 3210 Estero Boulevard, for which code case CE 190549 has been opened?
Yes, that is correct.
Can you please tell the Special Magistrate how you are so familiar?
Yes, investigation has led us to see that there has been an expired driveway permit for the property, and there has not been any permits to rectify the situation to fix the expired permit. no communication from the property owner or anything about the permitting process. And as of today, the property is still not in compliance.
Okay. Did you issue a notice of violation, notice of hearing to the property owner?
Yes.
Was the property posted with that notice of violation, notice of hearing?
Yes.
Has the property owner had any contact with town staff regarding this matter?
Not that I'm aware of.
Special Magistrate, as a result of the evidence testimony presented here in case CE 190549, we ask that the Special Magistrate, the similar order as in the previous case, which is same property owner, just slightly different permitting issue.
Could you check to see if this was the first violation for this property owner?
Staff has treated it as a
first-timer?
first time.
Okay.
Yeah, we're just really trying to get them to close out this permit.
I hereby find, it is hereby noted that there is nobody here present for the property owner. I hereby find that the violation as stated in the notice of violation did exist and continues to exist. Order the property owner to come into compliance by obtaining the building permit within 30 days. Otherwise, face a fine of $250 a day until the violation is corrected. I'm also assessing fees and costs in the amount of $75 as incurred by the town in bringing this matter before the magistrate. Obviously, if this property owner continues to do work without permit or expired permit, bring it to my attention regarding repeat violator.
Well, thank you, Special Magistrate. Next item on the agenda is number 25, the code case CE 190550. Officer is Eli Lee. Mr. Lee, are you, you've been sworn, correct?
Correct.
Are you an employee of the town of Fort Myers Beach as a code enforcement officer?
That's correct.
Are you familiar with the property and the code violation we're here for on CE 190550?
Yes.
This property, the owner, Laura Ray Mamone and Natalie Renee Nickerson, based upon your investigation.
Yes.
Okay. Please tell the Special Magistrate how you're familiar with this property.
Yes, I inherited the case from the last code enforcement officer, and I've been investigated ever since. The issue is that the property owners doesn't have a pool barrier around their property. As you can see in a picture of an area view from LIPA in 2019, there's no pool barrier around the property, and the town ordinance requires you have a pool barrier around the property for safety purposes. They don't have a pool barrier in 2019. And you look in 2017, like an area overview from LIPA, it showed that there was a pool barrier. So when they did construction on the property, they removed the pool barrier, but never, put it back or try to put some type of barrier around the property to make sure they came into compliance. As of today, the property still have not applied for any permits, and they're still in violation.
Have you had any communications with the property owner?
No.
Did you issue notice of violation, notice of hearing for this violation, and did you mail that and post that notice to the property owner?
Yes.
Special Magistrate, based upon the evidence testimony here presented this afternoon, we ask that you find the property and property owner in violation of the section of the code cited by the town staff. Because of the nature of this violation, we'd ask that the Special Magistrate, one, give the property owner an appropriate time to come into compliance, and two, the appropriate fine to hopefully motivate this property owner to bring this health, we believe health, safety, welfare. It's not just a town requirement, but it's a state law requirement that all pools, be safely secured, and leave it at the Special Magistrate's discretion as to what the appropriate fine should be, but also ask that you assess an administrative fee.
Hereby noted that nobody is here on behalf of the property owner. I hereby find that the violation as stated in the notice of violation did exist. And I hereby order the property owner to come into compliance within 48 hours Otherwise, face a fine of $250 per day until the violation is corrected, and I'm assessing fees and costs in the amount of $75 as incurred by the town in bringing this matter before the magistrate.
Thank you.
Your Honor, are you ready?
Yeah, case number 27. The property owner is Don M. Patton and Ibrahim Maliki. The property is at 190 Tarpon Road. The code enforcement case is 2019-0778. The officer is Officer Lee on behalf of Officer Stout. Officer Lee, you've been previously sworn, is that correct?
Correct.
You're employed by the town of Fort Myers Beach as a code enforcement officer?
Correct.
Are you familiar with this property and this code violation?
Yes.
Do you have an opportunity to review the file?
Yes.
Can you please tell the special magistrate what your investigation, your review discloses?
Yes. So after further investigation of the property on 190 Tarpon, there was a violation of a blight issue with the property as discussed. So the maintenance of the property has not been upkeep. It's sanitary, it's not safe, and that's what the violation is with the code.
Have you had an opportunity, or staff had an opportunity to try and contact the property owner?
Yes.
Has there been any response by the property owner?
No.
Was a notice of hearing, a notice of violation, notice of hearing provided to the property owner and posted on the property?
Yes.
Do the photographs that are in the file accurately reflect the condition of the property?
Yes.
Special Magistrate, based upon the evidence testimony presented here this afternoon, case 2019-0778, we'd ask that the Special Magistrate find the property and the property owner to be in violation of the section of the code cited by the town staff. Again, due to the nature of the violation and the condition of the property and that it's unsafe, we ask that the Special Magistrate give the property owner a short period of time to come into compliance, secure the violation. One of the photographs shows an open, I want to say pit, I don't even know what it is, but where someone could fall in and get seriously injured, and open studs and other things there at the property. So we'd ask that the Special Magistrate give a short period of time for compliance and also assess the maximum fine permissible, because the property owners had made no attempts to bring the property into compliance or communicate with staff. And again, due to the nature of the current violations, we believe that a maximum fine warranted.
But obviously, based on the pictures, it appears nobody's living on the property?
I'm sorry?
Based on the pictures, there's nobody living in the property?
No, it's vacant.
Okay. And the property is not fenced in?
No.
Did you observe any electrical components in the interior of the house with those open studs?
No, I personally did not go inside and investigate the property because from the outside looking in, it looked extremely unsafe to step inside.
But the photographs do show open electrical wiring.
Yeah. There's a reason that I asked.
Yeah, right there.
Yeah, so if you walk up to the property, you can see right through the property.
Or, all the drywall has been removed, and see all the electrical work. And Officer Lee, to the best of your knowledge, do you know if the electrical supply has been shut off, or is this an active electrical connection?
Not to my knowledge, I do not know.
We believed it to be abandoned. Obviously, there was somebody that lived there at one time who was deceased, and I believe that from what we can tell, we've spent a lot of time trying to contact this property owner, and it looked like it was left to the daughter and Dawn, and we've tried to find. I mean, we've looked in San Diego and Ohio, and we've really just searched to try to find this property owner. So The answer to your question is, I don't know if there have been permits for this work. It looked like, I think that tarp has been on there probably for a couple of years since the hurricane. So it's, we can't locate her, so.
Right, it is hereby noted that nobody's here on behalf of the property owner this afternoon in regards to this case. I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby ordering the property owner to come into compliance within 48 hours, otherwise face a fine of $250 a day until the property comes into compliance, and assessing fees and costs in the amount of $75 as incurred by the town in bringing this matter before the magistrate. And I'm also granting leave for the city to come back to the magistrate and request for entry of the property in order to secure it due to the health and safety issues that the condition of this property imposes, with cost to be assessed to the property owner.
In accordance with the statute and the code, we're actually asking for that authorization here today, if you'll give that to us.
Okay, based on the.
Yeah, based upon the health, safety,
based-
welfare.
Based on the town's request, I hereby amend my order to include the ability for the town to enter the property and secure the property as needed, especially probably fencing it in or boarding it up or whatever that is, cost which shall be assessed into the to the property owner, and shall this order become certified and be certified and become a lien, it will be included in that lien amount. Okay?
Thank you. Yeah. Special Magistrate, next and last case is item 28, citation 1428, case CE 190558, a violation of section 302.4 of the town code. Owner is Don Patton and Ibrahim Maliki Estate. The officer here to testify this afternoon is Officer Lee. Officer Lee, you've been sworn in.
Yes,
You're a code enforcement officer of the town of Fort Myers Beach, is that correct?
that's correct.
Are you familiar with the property at 190 Tarpon Road?
Yes.
Are you familiar with the issuance of citation 1428
Yeah.
that brought this case?
Yes.
forward? Can you please tell the special magistrate how you're familiar with this case?
Yes, further investigating the property for the separate issue, we noticed that there was high grass with the Fort Myers Beach Property Maintenance Code. Vegetation came to see over 12 inches. And the grass was overgrown, so it exceeded 12 inches, and we set a citation for the violation to be corrected. And I believe it has been cut since.
By town staff or by someone?
I do not know.
You have a date of when it came into compliance, or when you became aware that it was in compliance?
I became aware it came into compliance, I believe, the other week, a couple weeks ago, or a week or so ago.
Mr. Special Magistrate, based upon the evidence testimony as well as the actual citation that was issued, we're asking that the Special Magistrate find the property to have been in violation of the code section cited in the citation on the date that it was issued, and impose a fine of $250 a day plus administrative costs for the property being in violation on the date of the issuance of the citation.
Your Honor, if I may, the code officer believes that it was not cut. There is a lot of construction going on that street, and it is, the height of the weeds have now been reduced due to the fact that the cars or construction vehicles have been parked there, not because.
Is that the code officer's testimony?
Yes, no, that's correct.
Okay, so it has not been cut, it has just
Yeah, I've been cut, but of
flattened
course,
out by vehicles.
construction materials, they part their stuff, when they do construction down that way. So of course, the weeds seem to be lower because of construction materials on the property, in the grass.
All right, it is hereby noted that the property owner, there's nobody here on behalf of the property owners. I hereby find that the violations as stated in the citation did exist and continue to exist. I'm imposing a one-time fine of $250, ordering the property owner to come into compliance within 7 days. Otherwise, face a fine of $50 a day until the property is brought into compliance. And I'm also assessing fees and costs in the amount of $75 as incurred by the town in bringing this matter before the magistrate.
Mr. Magistrate, one last thing on
Yes.
that case. The same relief we'd ask that due to the nature of the violation and its relationship to the prior case that we just heard, that we ask the special magistrate to determine that the high weeds constitute health, safety, welfare, and authorize staff to take corrective action if deemed appropriate.
And authorizes on the basis that there is evidence that there are some divots and pits in the property, which high grass would obstruct the view of those areas on the site, posing a safety hazard. And therefore, I'm authorizing the town to enter the property to remedy the violation after those 7 days expire, cost of which will be assessed to the property owner. And should the order become certified, it will be included, the cost will be included as part of the lien against the property.
Thank you.
All right, I think that concludes our agenda for today.
Nothing further.
Thank you.